of Representatives, March 1, 2021. Message number 11. Mr. President, the House of Representatives appointed the following employees for the 2021 general session of the 66th legislature. They are as follows: Chris Carlson, computer floor clerk; Charlene Randolph, messenger; Katie Talbot, attorney secretary; Barb Austin, secretary; Kay Binning, secretary; Carol Clark, secretary; Mary Lee Dixon, secretary; Diana Hicksombaugh, secretary; Bonnie Jo Cruz, secretary; Sandy Dent, copy center clerk; Patty Mangini, chamber support clerk; Carol Nicolarson, Hirschler 1 West support clerk; Ed Mangini, gallery doorman; George Geyer, lobby doorman; Chris Bridwell, morning break room; Susan Long, afternoon break room. Signed, Wendy Harding, House Chief Clerk.
Reports from standing committees. You're still going.
March 1, 2021. Mr. President, your committee number 1, Judiciary, to whom was referred Senate File 90, Hemp Prohibitions and Requirements, respectfully reports same back to the Senate with a recommendation that it do pass. Ayes, Senators Cooper, Kolb, and Cost. Noes, Senators French and Nethercott. Senator Nethercott, Chairman. March 1, 2021, Mr. President, committee number 4, Education, to whom was referred Senate File 58, Wyoming Investment in Nursing Funding, respectfully reports same back to the Senate with a recommendation that it do pass amended. Ayes, Senators Beitman, Ellis, Rothfuss, Salazar, and Scott. Senator Scott, Chairman.
Okay, consideration of bills on general file. Mr. Majority Floor Leader. You've heard the motion. All those in favor? Aye. Those opposed, no. Senator Perkins. Committee of the whole will come to order. The next bill for our consideration is Senate File 5, driving under the influence of amendments. Will the reading clerk please read the bill?
Senate File 5, Driving Under the Influence Amendments, sponsored by the Judiciary Committee, was referred to committee number 1, Judiciary, which returned a committee recommendation that it do pass. Ayes, Senators Cooper, French, Kolb, and Cost, and Nethercott. Senator Nethercott, Chairman.
Thank you. Well, what's your pleasure, Senator Nethercott?
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report, it do so with a favorable recommendation on Senate File 5, driving under the influence amendments. And to explain this bill, I call on Senator French.
Thank you, Madam Chair.
Senator French.
Thank you, Mr. Chairman. Senate File number 5, Driving Under the Influence Amendments, sponsored by the Joint Judiciary Interim Committee. A bill for, number 1, an act relating to motor vehicles, creating a new crime for refusal to submit to a chemical test following issuance of a warrant, providing a penalty, amending driver's license suspension periods, providing for rulemaking, repealing a provision, making conforming amendments, and providing for an effective date. Be it enacted by the legislature of the state of Wyoming. Section 1 on Wyoming Statute 31-6-109 is created to read. So on this 31-6-109, refusal following issuance of a warrant penalties. So here's the new language on line 15. On A person lawfully under arrest who refuses to submit to a chemical test following issuance of a search warrant pursuant to Wyoming statute 31-6-102D is guilty of contempt of court, and in addition to pay a jail sentence authorized by the law, be fined not more than. So here's the meat of that. Line 5, Roman at 1, $750 for a first offense. Line 8, Roman at 2, $1,500 for a second offense within 10 years of the date of conviction. Line 12, Roman at 3, $3,000 for a third or subsequent offense within 10 years of the date of conviction. Then in section 2, those statutes are amended to read, those statutes, line 16 through 19, are amended to read on 31-5-233, driving or having control of vehicle while under the influence of intoxicating liquor or controlled substances penalties. So on page 3, line 11, after 404, for a period of its change from 2 years is struck and added is 3 years. On line 21, the addition is and shall provide notice to the department. On page 4, line 3 through 5, at the end of line 3, what's added is the department may promulgate rules for the administration of this paragraph. Under definitions on line 11, line 12, it's changed. It currently says through 31-6-101 through 31-6-108. That 31-6-108 is removed and 31-6-109 is inserted. Going on over to page 5 at the bottom, lines 20 through 23. If a person under arrest refuses to submit to a chemical test following the issuance of a search warrant pursuant to this subsection, he shall be advised of the penalties outlined in Wyoming statute 31-6-109 and 31-7-128. On the next page, page 6, line 4 through 6, after the word more, it's inserted the new language, or the person refuses to submit to a chemical test following the issuance of a search warrant pursuant to subsection D of this section. Then following down to the bottom, lines 18 through 21, after the word person on line 18, it's inserted, or the person refused to submit to a chemical test following the issuance of a search warrant pursuant to subsection D of this section. Page 7, line 2 through 5, after it says, spells out 1% and 0.08% or more. Right after more, what's added is, or the person refused to submit to a chemical test following the issuance of a search warrant pursuant to subsection D of this section. The bottom of page 7, line 21 through 23, it's added, whether the person refused to submit to a chemical test following the issuance of a warrant pursuant to Wyoming statute 31-6-102D. We're on page 8, line 3, after Romanet 2 is added and paragraph D, or D is added there. Nothing further on 8, page 9, at the top, line 1, after the word the within the 5-year is struck, and inserted is 10-year. And they spell it out 10 and then 10. Then as you go down on 631-7-128, mandatory suspension of license or non-resident operating privilege for certain violations, suspension of registration. Line 10 through 22. On O, upon receipt of the statement provided for under Wyoming statute 31-6-102 E, asserting the person refused to submit to a chemical test following the issuance of a search warrant pursuant to Wyoming statute 31-6-102 D, the department, subject to review as provided in Wyoming statute 31-6-103 and 31-6-104, shall suspend the person's Wyoming driver's license or his privilege to operate a motor vehicle in this state as follows. Line 19, Romanet 1, 90 days for the first refusal. Line 21, Romanet 2, 6 months if the person has previously been suspended under this subject section within this act. On page 8, line 3 is added after the 31-6-102. A, Romanet 2 is and D. So we're going over to page 9. Again, on line 1, after the 5 is taken out and 10 for a 10-year is inserted. Line 10, upon receipt of the statement provided for under Wyoming statute 31-6-102 E, asserting the person refused to submit to a chemical test following the issuance of a search warrant pursuant to Wyoming statute 31-6-102 D, the department, subject to review as provided in Wyoming statute 31-6-103 and 31-6-104, shall suspend the person's Wyoming driver's license or his privilege to operate a motor vehicle in the state as follows. Line 19, 90 days for the first refusal. Line 21, 6 months if the person has previously been suspended under this subsection. And then on page 10, line 1 through 8, last 10 years, and that suspension was uncontested or upheld following the administrative hearing. Line 4, Romanet 3, 1 year if the person has previously been suspended 2 or more times under this subsection within the last 10 years and previous suspensions were uncontested and upheld following administrative hearing. And over on page 11, lines 3 after 750, line 3 through 11 after 30 days is struck. This act is effective July 1st, 2020. I talked with Colonel Reiner, I guess Director Reiner now of, I used to know him as Colonel Reiner, Director Reiner of YDOT. I talked to him about it, and he's really supportive of it, as is the Highway Patrol. What it does, if he was saying that there's a growing trend out there that when a forced blood draw is issued, that some people are not doing that, not taking the blood. And some sheriffs aren't following up on it. Some prosecutors, this was his words to me. So with that growing trend, what this does is versus them, if somebody doesn't do that, them walking, there's some pretty severe consequences. So I would recommend the body pass it. And that was pretty long-winded, forgive me for that.
Okay, does that conclude your explanation, Senator French?
Yes, it does.
All right, thank you. So we're on the bill. Senator Landon? No?
Thank you.
Senator Hicks?
Mr. Chairman, I read this and I got some questions, but it looks like a prosecutor's dream to me. But that would be the first question I have is so at what point in time does the due process rights of the individual come in? From the time that they've been pulled over, there's a suspicion at this point in time that they may be under the influence. And I'm assuming that this is more directed not at alcohol, but controlled substances, the reason that we might need to do the chemical test. But once that happens and that person refuses, they refuse after the search warrant has been issued, as I understand it. But what point in time would this person have an opportunity to be represented by a lawyer in that process if they chose not to do the chemical test? Or do they ever get to the point, is it after they get to court? I just want to know where due process fits in this whole process. And is this designed to try to get at more of those controlled substances? Or is it, do we have the lack of ability with our current breathalyzers and sobriety tests for alcohol? So just a couple of initial questions, Mr. Chairman.
Thank you. Senator Hicks, Senator Landon?
Thank you, Mr. Chairman. And I think that my friend from Bags just asked the same question that I had in my mind, and mine is perhaps even more elementary. I was just wondering if the committee could help me with, when am I lawfully under arrest? In other words, if I get pulled over, my understanding was that a law enforcement officer could ask me, you look like you're weaving around a little bit, and let's walk a little bit, and how would you blow into this thing? If I say no, I'm not lawfully under arrest, right? As in paragraph A, 33.6.109. I'm just wondering at what point, I think it ties in with what the senator from Carbon County was getting at too. At what point are we under arrest? Thank you.
Thank you, Mr. Chairman. My question's a little bit different. It involves when I was reading about the chemical test, I was looking for a definition, didn't see one in the bill. I'm looking through the statutes and I don't see one there. Closest I got is 31.6.105, method of performing a chemical analysis, which doesn't have the same verbiage, obviously, as chemical test. So a little explanation on the difference, if there is one, and why there isn't a definition of what exactly is a chemical test. Thank you.
Thanks, Senator Whiteman. Senator French?
I can maybe answer part of it. Then I'll turn to my good chairperson to follow up. They're not arrested unless there's probable cause. I mean, they're following you down the street, or they get we used to call it ready report that this vehicle's weaving all down the highway, and they catch up to them, or they witness it themselves, and they have probable cause. They suspect the person is under the influence of drugs or alcohol. So at that point, when they pull it over, then they go through their series of steps to, all right, whether it's a breathalyzer or walk or count backwards or whatever their tests are, stand on one foot, those types of things. So that at that point, okay, this was a legitimate stop. So get in the back seat of the car, and they take them to the jail. And at that point, they ask a judge for a blood draw, because that's the most effective and most accurate test there is, the blood and urine. And this is according to Director Bidner. So at that point, it's like, Okay, and I don't know why, I don't understand why, but somebody that said, all right, hold this person, draw their blood. And whoever that medical person is says, no, I'm not gonna do it. So at that point, what happens? They don't have enough to go to court, under their field tests, I guess. They want that blood draw and urine draw is the most accurate. So.
Thank you, Senator French. Senator McCown.
Thank you, Mr. Chairman. I find part of this bill problematic as we talk about chemical substances. And I'm not going to tell you why I know this, but if someone smokes a lot of pot, the blood level goes up and it stays up. That's the problem with finding out when they're actually under the influence or not. So we're going to give them a chemical test. And if they're a regular user of marijuana, the numbers are going to come up really high, even though, pardon the pun, they're not high. And it takes time for that to work out of your system. And there's many other substances like that. So to say a chemical test is the answer and then bump the fines up through the roof, I just don't like that part of the bill. Thank you, Mr. Chairman.
Senator Nethercott.
Thank you, Mr. Chairman. Deep inhale, everyone. So the bill is actually not that exciting in reality and doesn't do anything that really isn't currently allowed. The reason why this bill was brought to the committee was really to create conformity between two different areas of law. One is 31.5.233, which is actually the criminal statutory section for driving under the influence. And that's driving under any kind of influence, whether it be alcohol, substances, or other type of chemical influence. As we know, you can huff rubber cement and drive unsafely, and that's illegal. And so it's important to kind of recognize those pieces. So there is not parity between 31.5.233 and the second concept associated with DUI, which is your driver's license. And so what this bill focuses on is the statutory section of 31.6.101, which is the implied consent to chemical testing as associated with the privileges of your driver's license, which is not the same as your due process rights for a criminal conviction. They do exist and you do have property rights associated with that driver's license, but they're very limited and not the same as if you were charged with a crime. So when someone is pulled over for a DUI, both of those statutory sections are triggered for a criminal potentially conviction and then also for your driving privileges. And those two processes are not the same. And so it's possible for an individual to lose their driving privileges while not being convicted of the underlying charge. Although that's rare, it certainly is possible. And one of those has to do with implied consent. So as part of our privilege of receiving a driver's license in the state, we agree to implied consent to provide a breath test, usually some type of puff type machine where you breathe into the intoximeter to determine alcohol consumption. If you're behaving badly as a result of intoxication and you refuse to do that and don't honor your privileges associated with your driver's license, and the officer still wants to determine your blood alcohol content associated with chemical intoxication, regardless of the source of the intoxication, Wyoming legislature over a decade ago authorized the use of a forced blood draw. You've heard me speak of this before, allowing the defendant or the suspect to be taken to a medical provider or to the jail to have their blood forcibly drawn pursuant to a search warrant. So a search warrant is authorized, and so a judge approves that draw and their blood is received. And that's part of the privileges associated with the driver's license. And so that's the story here. The definition for a chemical test is found in 31.5.233 Romanet 8. A chemical test means a test which analyzes an individual's breath, blood, urine, saliva, or other bodily fluids or tissues for evidence of drug or alcohol use. So it's also important to note that before technology, law enforcement was able to pull an individual over and arrest them for driving under the influence of alcohol or other intoxicating substances without proving on the side of the road what that was. If you're just driving safely or unable to operate a motor vehicle safely, you can still get convicted of a DUI. So those pieces have always been around and aren't anything new under our law. So the purpose here is to provide some parity between those two different parallel tracks associated with driving under the influence, and also to put a little bit more teeth into what has been occurring in the state of a refusal for that blood draw to occur as a result of concerns over liability or other issues, that forced blood draw is statutorily authorized for more than a decade.
Thanks, Senator Nethercott. Senator Bouchard.
Thank you, Mr. Chairman. As I look at this bill, I mean, on page 9, it has all the provisions, how the license becomes suspended. And oddly enough, that's the only part of the bill I really like, because that's what they do in a lot of states. They just take your license away if you refuse. But what we've done is we're building on a decade of stuff that we should have never done in this bill. So that's where I'm at. Why don't we just do like other states? So this is the question to the chairman. Why don't we just do like they do in other states and take the license away, and then have all the provisions that if they're driving with a license or without a license that we're punishing for that? Why are we going to so much trouble here to just beef up a statute that we probably should have done in the first place? So that's my question.
Thanks, Senator Bouchard. Senator Rothfuss.
Thank you, Mr. Chairman. I wanted to pile on to that a little bit. I think it was about 10 years ago, if I'm not mistaken, 11 years ago, when we debated this. I remember the debates on this floor, and there was a lot of discussion, and it was a pretty narrow debate, because there certainly was a feeling, Mr. Chairman, of discomfort among many, including myself, of the idea of a compulsory blood draw prior to any guilt, right? So this is part of an investigation process, and it's effectively a presumption of guilt. It does go through the implied consent. There is unquestionably Supreme Court support for this approach, but it doesn't mean it's the right approach, and it doesn't mean we have to do it just because we're allowed to by the Supreme Court. To be honest, I've always been a little bit creeped out by the idea that your blood can be forcefully drawn and then used against you. Again, it was upheld by the Constitution. It doesn't make it any less creepy. And the idea that now we want an individual held in contempt of court and effectively presumed guilty, presumed to be in contempt of court for a denial to turn over their blood, again, even if they're innocent. So they could prove at the end of it, once the blood is forcibly drawn, to have a 0% of whatever it is you're looking for as you're fishing. 0%, but you're still guilty of contempt. And I still don't understand the due process, Mr. Chairman, that we were asked about by the good vice president. And I don't see it. So I realize there's a search warrant, but we fast tracked those search warrants a few years ago to the point where it's pretty much a point and click search warrant. I don't think anybody even has to write their name. I think you could probably just drag a signature onto it, click over the app, search warrants issued. I have more complicated transactions on my cell phone for banking. So the idea that this is all well and good because there is a process and because we're constitutionally allowed and we're not breaking any laws, again, doesn't mean it's the right thing to do. And adding to it, making it even more stringent, more restrictive, building upon what we've done over the past few years, as my good colleague stated, where maybe we shouldn't have done that in the first place, does give me some discomfort. And again, there are some good provisions of this which conform. I agree with the good chairwoman. A lot of this is conformance. It's trying to make the statutes harmonize one to the other. So I think there's good work here. But the presumption of guilt component that provides for an opportunity to pile on additional charges if I'm unwilling to surrender my blood immediately is something that we should really seriously consider, I think, as a chamber. We shouldn't consider it just a cleanup. We should decide independently whether that's something we're comfortable with, Mr. Chairman. And I'm certainly not comfortable with it without a great deal of additional comfort.
Thanks, Senator Rothfuss. Senator Nethercott.
Thank you, Mr. Chairman, and certainly policy questions for the body. But you're being asked to make the law on the books make sense. In the future, a bill draft, repealing all of that, certainly welcome those conversations. But so for right now, the bill in front of us, the purpose of the bill is to make it make sense. I think it's helpful in these cases to understand some of those factual scenarios where this can take place. And one is over the joint judiciary, we heard testimony from frustrations from law enforcement and the inability to prosecute from an individual who had been under the using methamphetamines, illegal methamphetamines, which obviously metabolite very quickly in the body, drove all night long, wrecked the following morning, killed a lot of people, and of course not the driver, and they were not in a position to consent and needed to get a warrant to get their blood to determine the level of how much they were under the influence at the time of ingesting the methamphetamine to the time of the crash. And so that's an example of how the law gets used on the ground in one of those horrific stories. But I think it's helpful to see some of that and how that plays out, and the need for the blood draws to determine a criminal investigation associated with homicide. And so those pieces come together in those ways.
Senator Guru.
This time I'd like to move Committee of the Whole Amendment number 1 to Senate File 5 and ask it to be read in at this time.
Thank you. Will the reading clerk please read the Committee of the Whole Amendment number 1?
Senate File 5, Committee of the Whole Amendment number 1, page 2, lines 5 and 6, delete.
Now I'd like,
Senator Guru.
thank you, Mr. Chairman. Now I'd like to move Committee of the Whole Amendment number 1 to Senate File 5, and I'll explain. Thank you. What this amendment does is actually just change the fine structure from $750 to $0 on the first offense. And that's all it does. And if you look at the amendment, it just changes some language, but then clearly points out that a $0 fine on the first offense. To be honest, I'm not wild about this bill for a couple of different reasons, but as a former president of this body always used to say, we should always try to make a bill better, whether we like it or not. And I think this does. And the reason why is simple. I don't want to get into second and third offenses and what people do in gaming systems and all that, and things that prosecutors and things that policemen talk about. I'm just thinking about that person who's driving home, whether it might be some young person or even an older person who's driving home from a party or from a dinner or something, and all of a sudden those lights light up behind them, and all of a sudden all this stuff starts going through your mind. Did I have that extra glass of wine? Was I weaving? Your pulse starts to go up. All of a sudden that secretion of adrenaline starts to fill that metallic medicine or feeling in your mouth. Then all of a sudden the policeman comes up to your car and starts asking questions. And at that moment, everything starts to fog over. Maybe it sounds familiar to you. Maybe you can tell that it sounds familiar to me. But either way, the point is that sometimes you don't know what to do. And maybe you don't know that your driver's license is privileged, not a right, and what due process is and what it isn't. Maybe sometimes you just want to call your mom. Maybe sometimes you might want to say, hey, I want to talk to a lawyer before I do anything. And so when they ask you, do you want to submit to a breathalyzer test? And you say, no, I want to talk to my lawyer. I watched enough episodes of Law and Order. I want to talk to a lawyer. Well, they slap the cuffs on, and then all of a sudden you're off to the races. And there you are. And so now, just because you made a decision out of caution, all of a sudden, you're now gonna get, if you blow a 0.09, you're gonna get a $750 extra fine onto the somewhere around $25,000 cost that's associated with a very humiliating experience, which is designed specifically to do just that, humiliate you into what we all know is true. Don't drink and drive. So when I say that, I say other reasons, we'll talk later about why I'm not wild about this bill, but for this, on and for this amendment, that is the reason why I brought it. Thank you, Mr. Chairman.
Senator Root, thank you. We're on the amendment. Discussion on the amendment. Are you ready for the question on the amendment? Should the Senate adopt Senator Garu's motion to adopt second reading amendment, committee of the whole reading amendment number 1 to Senate File 5? All those in favor say aye. All those opposed say no. The ayes have it, and it has passed. The amendment is adopted. We're back on the bill. Further discussion on the bill. Senator Cole.
I'd like to add another story, and it probably didn't end as good as the last one did with embarrassment. It happened in Sweetwater County. I heard the statements of the law enforcement folks that were there that picked up the pieces, including a dead body. And it involved someone who was, they believed, intoxicated. The issue was they didn't get a warrant out in time, and they had to life flight the person to Utah, and they lost the evidence that they could have used and could have had before it left the state. My point is that it is a privilege to drive. It's always been a privilege to drive, and if folks don't know that, I suppose maybe that needs to be part of their driver's license test. We've got issues with fatalities, which are real. I realize maybe folks should call Uber, and you shouldn't drink and drive, obviously, but it happens. And when it happens, I think, some well-versed people know that it's in the best interest to refuse that blood draw. And no offense to the attorneys that sit in this fine chamber, but that's what's been disseminated. And we have another tool in our toolbox, and I think we ought to utilize it to send a message that there is a consequence for driving drunk, and refusing the test isn't going to be the solution for that, and hoping for the best result in court. So I think it's a good compromise in dealing with modern times and modern issues. Thank you.
Thank you, Senator Kolb. We're still on the bill. There's a further discussion on the bill. Ready for the question? The question is, shall the find my right bill here. Question is, all those senators who in favor of Senator Nethercott's motion, and when the committee of the whole rise report, do so with a favorable recommendation on Senate File 5, please say aye. Aye. All those opposed say no. Yeah, I believe that the bill has failed. That requires a standing division. So all those in favor, please rise. So on you on the screen, if you're rising, raise your hand, please. Okay. I did see a head shake from one of them. The other one may be just I think one of them may just be in a loop. Pardon me? Okay, 15 in the chamber. All those opposed, please rise. No center land and sitting. That's how many? How can that be? Are you doing 2 on the screen? There's 2 on the screen. 2 remote. Okay, the vote is 15 ayes to 11 noes. The bill has passed committee of the whole. Next bill for our consideration is Senate File 13. Will the reading clerk please read the Senate file?
Senate File 13, Abandoned Vehicles Towing Service Liens and Titles, an act relating to motor vehicle liens, sponsored by the Transportation Committee, was referred.
Heard the reading of the bill. Who is our transportation chairman? There we are, Senator Landon. What's your pleasure?
Mr. Chairman, I believe the reader was going to finish up, or is he finished? Are we good?
Did you finish reading? Oh, you're right. Hang on. Thank you.
Thank you very much.
My apologies. Was referred to committee number 8, which returned a committee recommendation that it do pass. Ayes Senators Furphy, Landon, McQueen, and Pappas. Excused Senator Anderson. Senator Landon, Chairman.
Now, Senator Landon, what's your pleasure?
Thank you, Mr. Chairman. I would move that when the committee of the whole rises to report, to do so with a due pass recommendation on Senate File 13, Abandoned Vehicles Towing Service Liens and Titles. This is a product of your Transportation Interim Committee. It is, for the most part, a pretty lengthy cleanup on some very difficult portions of our statute. And to really clarify and smooth that out for you, I would ask that you call on the good senator from Laramie County, who's going to explain the bill for you, Mr. Chairman.
Well, there's 5 good senators from Laramie County, but we'll call on Senator Pappas.
Thank you, Mr. Chairman. This, just a little background before I take you through the bill. This issue, the issue on this bill is when a vehicle is towed and not claimed by the owner, the towing operator has options to dispose of the vehicle in 2 different methods, either under Title 9, which is lien sales, or Title 13, which is abandoned vehicles. So, and the language in these 2 statutes creates confusion among all the interested parties over which process to use when owners do not claim their vehicles. So the revisions in this bill basically clarify the process towing operations should follow when the interested parties are known and identified. Also allows towing operations to be more efficient and cost-effective when disposing of unclaimed vehicles. It streamlines the notification process and storage limitations in both of the statutes. And the changes will benefit constituents, industry, the county officials, and pretty much every interested party. So just a little bit of history. The Wyoming Towing and Recovery Professionals Association requested this as an interim topic last year, and it was sent to Joint Transportation. We met in September. The association presented their concerns to the interim committee, detailing the inconsistencies with Title 29 and Title 31 and the need for clarification. After hearing the testimony from these parties, the committee requested a working group to be compiled and present a draft legislation. And that happened. The working group got together after that September meeting. It consisted of the Wyoming Towing and Recovery Professionals Association, the county clerks, the insurance industry, folks from law enforcement, and YDOT. So this group came back to us with full consensus, and in November, when we met, voila, Senate File 13 was appeared. So that's the history. Let me just run through the bill real quickly. I'm not going to go line by line, but I'll go by sections and tell you what the actual changes consist of. So basically, there's three sections we're changing in the statute. Title 29, Chapter 7, Title 31, Chapter 2, and Title 31, Chapter 13. So first of all, 29.7 is regards lien sale. This offers industry a recourse when a known owner fails or refuses to claim the vehicle and establishes guidelines for disposing of the unclaimed vehicles. So the first item in the bill basically adds a new paragraph. It's 29.7.101B, persons entitled to a lien. If you look on page 2, lines 2 through 12, clarifies a towing service is not a warehouse and is entitled to the storage lien process under Title 29 rather than the warehouse lien process that is under 34. So you can see that in lines 9 and 10. Moving on, we have a new paragraph, 29.7.102E. You'll see this on pages 2 and 3 about lien notification requirements. This sets the requirements to owners and lien holders to ensure that they can identify the vehicle location and recovery fees. The language is consistent with requirements in Title 31 for abandoned vehicle notifications. On page 2, lines 19 and 23, and also on page 3, lines 1 and 13, you'll see that this requires notice sent within 30 days by certified mail and will include things like the amount due, the nature, the time, the place of sale, information required for a perfected lien, and automobile specifics like make, model, and VIN number. On to page 3, lines 13 through 19, you'll see that storage fees now cannot exceed 180 days. This prevents unlimited accrual of storage fees and ensures the vehicles are disposed of in a timely manner. This makes it consistent with 29.7.104, the termination of liens. And the changes that we'll get to on page 11 in 13.109, abandoned vehicles. So all of this is intended to make the two statutes consistent. On to Title 31 now, Chapter 2, junk vehicle titles and registrations. This offers towing operations a recourse for disposing of lien sale vehicles worth less than $2,000. The you'll see on page 4, all of page 4 basically, and lines 1 and 2 on page 5. We're adding a new paragraph E under 31.2.11, which is towing and recovery carrier junk vehicle titles. This adds language for junk title applications, including lien sales that are worth less than $2,000. It streamlines with provisions for abandoned vehicles worth less than $2,000 and expedites the process and decreases costs for industry to dispose of unclaimed junk vehicles that are not abandoned. Okay, let's move on to Title 31, Chapter 13, abandoned vehicles. This resolves inconsistencies within Chapter 13 that were brought by the Towing Association. The changes clarify notification requirements and recovery of storage fees. So you'll see on page 6, there's some changes. Lines 3 and 10, it replaces retail value with fair market value to allow for consistency in Chapter 13. Because the conditions of the vehicle, condition of a vehicle may not really align with the retail value. And on page 7, lines 6 and 7, it inserts return receipt requested to clarify requirement for proof of service to process abandoned vehicles. This was a request by the county clerks. Now we'll go on to 31.13.108, disposition of abandoned vehicles impounded by law enforcement. We've got a change here too to make it consistent. If you look page 7, line 22, and page 8, line 8, Again, we're replacing retail value with fair market value to allow for that consistency. On to 3113-109, disposition of abandoned vehicles, private property. We're making some changes here as well. Page 9, line 16 through 22, strikes out language designating vehicles as abandoned when left unclaimed at a repair shop or towing business. This scenario is covered by Title 29 lien state sales statutes. The change here clarifies to all parties which process towing operation should be used. And this was actually brought by industry to the group, to the working group. Page 10, lines 2 through 4. There are inconsistencies in notice requirements between 3113-104 and 3113-109. And this change streamlines the abandoned vehicle notification towing operations to follow the process in 3113-104, specifically paragraph G. Again, this item was brought to us by industry as well. Page 10, line 10 clarifies that a license plate number is not required in the notice if that information is available. Typically, a lot of times vehicles that are recovered don't have a license plate. So we're just sticking in there if it's available. Page 11, line 15 through 18. This removes the limitation of storage fees and expenses, which allows towing operations to recover their costs on private property abandoned vehicles. The limits are intended to prevent county abandoned vehicle fund from being depleted. However, the fund is only used for vehicles recovered on public property or impounded by law enforcement, which is in actually 3113-108. So none of that gets changed. The existing limitations still remain in 108. And then finally, the last item, page 11, lines 18 through 23. Storage fees cannot exceed 180 days. This prevents unlimited accrual of storage fees and ensures the vehicles are disposed of in a timely manner. So this now is consistent with what we changed in 29.7.104, termination of liens, and the changes on page 2, which was 29.7.102, lien sales. So with that, I can try to take any questions that you want. I can tell you that all parties were at the table when this was drafted. These changes make sense for both the clerks, for law enforcement, and for the industry. So I welcome your favorable vote on this legislation.
Thanks, Senator Pappas. Senator Schuler.
Thank you, Mr. Chairman. Just a couple questions that came to mind when I first read through this. How does the junk title, how does that differ from a salvage title? And also, if you could answer just as a follow-up, do those have to be disclosed? Like if the person that decides the junk guy, let's say he decides to go ahead and sell that vehicle, is it listed as a junk junk title, or is it listed as a salvage title, and how do they differ? I guess I need a little bit more information on that. Thank you, Mr. Chairman.
Thank you, Senator Schuler. Senator Bouchard.
Thank you, Mr. Chairman. You know, I wasn't part of this bill or working it, but I can give you the industry background on this. I spent a lot of my life in the automotive industry. So what you have here, and I want you to understand that this bill handles it for the towing sector, but this is the same problem they have in automotive shops. If somebody wants to get rid of a car, bring it in and get it looked at, man. And a shop ends up with a junk car that they can't get rid of. So what happens on a junk title is they have to get that car in. It's not worth anything. Move that thing out, just get rid of it, sell it. And it has to be, that's why this is being done. In essence, what's going on is they'll get a call from either the PD or the sheriff's department. Hey, we got an abandoned car. And obviously, if it sits there so many hours, it's abandoned, and they have to pick the car up. And when they do, they have to tow it into their yard. So it's taking up real estate inside of their yard. Do this enough times, they can't fit cars in their yard. So as this starts happening, it's really it's mandated on one end, but then the tow yard can't do anything with it on the other end. So all this language is doing is cleaning everything up and making it happen. There's the ability, they have to notify. A lot of states do lien sales the same way. You notify them by mail with the last registered address that either the driver's license or the car, they have it in the system. And so this all goes through all the process and makes it streamlined so they can get rid of the car and understand they're at odds because they're saying, well, the PD made us do it. We're on rotational and we have to do this. So now they're going, well, wait a minute. We've had to do this and our yard's full of all these cars. And trust me, people don't want these cars. So, and there are cars that they do end up with that are nicer cars every once in a while. For whatever reason, people, they just don't do what they're supposed to do in life. And there's consequences for that, right? They'll leave a car. So, I mean, so it's not just, so that would be the junk titles. The junk titles would be the ones, they don't want them anyway. There's other cars that they'll pick up on for the same reason. It could be a DUI call where somebody ran and left a car. It could be that too, but there has to be a process for them to clear those cars through and get rid of them. So that's my explanation. Thanks.
Is there any further discussion or questions on the bill? We're on the bill. Senator Pappas.
Yes, thank you, Mr. Chairman. To the question about junk title versus salvage title, salvage, that's something I don't know about. The word salvage doesn't appear in the bill. It would be something that I would have to, perhaps Senator Bouchard, he's probably more knowledgeable certainly than I am. Is there a difference between a junked vehicle and a salvage vehicle? I don't know. So perhaps he can answer that.
Thank you, Mr. Chairman. So a salvage title is when you have a car that went through a wreck. And what happens is that the insurance company will actually sign it off as a salvage. And then you have to go, it's really an easy process. You don't have to do much of anything. And it goes through and you actually salvage it. The insurance company will not insure it the same way, but you can actually own a salvage car and drive it. The junk title is totally just so these guys can get rid of it. Nobody wants the car anyway. And then you don't have to go and change titles, go through a title process to get rid of the car. So that's basically the difference of the two things.
Senator Bouchard, here for the question. All those in favor of Senator Land's motion, that when the committee will rise and report that it do so with a favorable recommendation on Senate File 13, say aye. Aye. Those opposed say no. Motion has carried and Senate File 13 has passed committee of the whole. The next bill for our consideration is Senate File 30, Pandemic Response Review Task Force. The reading clerk, please read the bill.
Senate File 30, Pandemic Response Review Task Force, an act relating to public health, sponsored by the Corporations Committee, was referred to Committee Number 7, which returned a committee recommendation that it do pass amended. Ayes Senators Boner, Case, Driscoll, Nethercott, and Scott. Senator Driscoll, Chairman.
Thank you. It's funny you don't look like Senator Driscoll, Senator Boner, but we'll let you take it. Senator Boner.
Well, you're going to be disappointed, Mr. Chairman. This actually has an appropriation, so I asked that be referred to committee number 2.
I love it when the plan comes together. I don't know that I can read. I have the authority to re-refer that. So
well, we might want to
we'll
play this one back.
So what we'll do is did you just ask this be laid back one day or laid back until further action will be taken? All right, without further objection, it is so ordered. Our next bill for our consideration is Senate File 88, Ownership of Fossils and Artifacts. We're hoping that some senators do not take this personally. So with that, please read the bill.
Senate File 88, Ownership of Fossils and Artifacts, an act relating to property and conveyances, sponsored by Senator Cost, was referred to Committee Number 6, which returned a committee recommendation that it do pass amended. Ayes Senators Ellis, Guru, Landon, Salazar, and Schuler. Senator Ellis, Chairman.
Thank you. You've heard the reading of the bill. What is your pleasure, Senator Ellis?
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report, it do so with a favorable recommendation of Senate File 88. There is a standing committee amendment, and I'd ask that it be read at this time.
The reading clerk, please read the amendment.
Senate File 88, Standing Committee Amendment Number 1, page 1, line 13, after.
Thank you, Mr. President.
Senator Ellis.
Thank you, Mr. President. To explain this bill and the amendment, I'd ask you to call on Senator Cost.
Senator Cost.
Thank you, Mr. Chairman. For this good little bill, good big bill, good important bill, whatever we want to say. It's about ownership of fossils and artifacts. And one of the things that we found out, and a person in one of my counties had brought this up to, because it happened to this particular person. Legally, there's nothing in our state that really says who the ownership of the fossils are. And so I started digging into this, to try to find out a little more and try to see if we could work to come up with something. In the process of that, we were able to come up with this particular bill, ownership of fossils and artifacts. At the time, I had no idea the value of these fossils. Some of these larger dinosaur remains and all are extremely valuable. I mean, I thought maybe, a few thousand, maybe a little bit more than that. We're talking millions with some of these, which is really kind of like, whoa, this is pretty important. So this bill really does have some value for the person that owns it, and trying to make sure that we've got the right people involved was important. To read what the property is: an act relating to property and conveyances, specifying ownership of fossils, artifacts, and non-fossilized animal remains discovered in split estates and providing for an effective date. And of course, with minerals and mineral rights, as it's sold down through the years, all of a sudden this person kept mineral rights and that person kept mineral rights to where they were pretty well watered down. This is hopefully going to take care of that with fossils, not with minerals, and make a solid bill that's going to be to the benefit of the landowner. If you read section 1, statute 34-1-154 is created to read ownership of fossils and artifacts. And this is where the First Amendment comes in, is at this point. And I'm going to be bold and say that we are going to ask of you to not be in favor of this amendment, not be in favor of this amendment. So we're asking you to vote it down. Basically, the ownership of any fossil artifact or non-fossilized animal remains discovered in the strata below the surface lands and waters of the state is vested in the owner of the surface estates unless otherwise clear and expressed grant governed by Wyoming Statute 74-106. And let me tell you that 74-106 is archaeological human burial site remains, and it's important for us to have that for the respect of those that have been buried throughout the land. So this is the statute that protects that, and it's added into here for that protection still. Excuse me. When used in any instrument, the Second Amendment is going to be removing this, and I will ask maybe to have that read in at this time. Okay, I have a committee of the whole amendment that will need to be moved. So we'll do, can we act on that one? And I'll ask the boss to speak.
Thank you, Mr. Chairman. I would move committee of the whole amendment number 1. I would ask this body to vote no. During our discussion of the bill, there was some confusion and some concern about how deep that strata would go. And so we did pass this amendment as a bit of a placeholder to have a further discussion and analysis on it. The good senator who brought this bill provided me with a copy of the court opinion. And in that opinion, it provided a very workable definition, which we've shared with industry. And basically, it's a common industry understanding that anytime you have a surface owner who is using the land or having some kind of development or improvement put on their land, whatever is reasonable to make that connection between the surface and anything that might be considered a little below. So something like if you were building a house or a new structure and wanted to add a basement, if you were adding, fences, those kind of things that dig into the earth would be included in the surface. And so with that, we'd ask you to not put the 100-foot definition as requested in Committee of Whole Amendment number 1. Thank you, Mr. President.
Thank you.
Or Mr. Chairman.
Thank you. Point of order, Senator Rothfuss.
The good chairwoman referred to Committee of the Whole Amendment number 1 in her motion. And I think it was just a misstatement, and I think she means to move the standing committee amendment. So just that point of order, Mr. Chairman.
Thank you for that correction. Senator Ellis, would you come back and help
Thank
us
you,
with
Mr.
that?
Chairman. Good catch. I move standing committee amendment number 1 to Senate File 88 and would ask the body to vote no.
Okay, is there further discussion? We're on the amendment, standing committee amendment number 1. Is there further discussion? Question, all those in favor of Senator Ellis's motion to adopt standing committee amendment number 1, say aye. All. There's one on the screen. All those opposed, say no or raise your hand at this time.
Poor Senator.
The noes have it, the amendment has failed. We're back on the bill. Would you like to deal with the standing committee whole amendment now, Senator Cost?
Yes, Mr. Chairman.
Let's go ahead and read that in then.
Senate File 88, Standing Committee Amendments number 1, page 1, line 13, after. Correction. Senate File 88, Committee of the Whole Amendment number 1, corrected copy. Page 2, line 1, delete.
I love it when a plan comes together. Thank you, Mr. Reader. Senator Cost.
I would like to move Committee of the Whole Amendment number 1 to don't say point of order, I'll get it right. To Senate File 88. Okay, and to move forward with an explanation on that. And by the way, I would like to express my sincerest appreciation and admiration for the president and chairman and leader in extraordinaire of the TRW, because she has done an amazing job with this, and she could probably do a heck of a lot better job of presenting it than I am. I would say that she is very eloquent with her speech, and I stumble over my own name. So we'll work forward on that. Anyway, I shall digress.
Hey, we still refer to her as Chairman Ellis instead of President Ellis, though. Is that okay?
I don't know. She's right up there. We'll give her that, though. Thank you. So this amendment starts on page 2 on line 4 with B, where it says, when used in any instrument, this strikes out unless the clear and express terms of the content of the instrument provided otherwise. So that's going to be striked out. So it's going to read, when used in any instrument, the term mineral does not include fossils, artifacts, or non-fossilized animal remains. When we go on down as used in this section, there's the definitions of a fossil, an artifact. And then section 2 says, this act shall apply to any existing, excuse me, or future transfer of ownership of the strata below the surface lands and water of the state. And get to page 3 here. There we go. Seems to me. Did I leave something out? No. I just wanted to make sure I didn't. I did leave something out. On line 15, page 2, line 15 is the most important part of this. And that is to insert after include coal, oil, and gas, because those are the minerals that we want to make sure in. Coal was left out. We wanted that inserted. And then, of course, this is effective July 1st of 2021. The important thing for us to remember that with this is, number one, the land and the fossils belong to the landowner, and that's not going to be divided up or broken down. This makes this much simpler when you're selling land. I can't imagine anybody selling land and somebody saying, well, I'm going to keep my fossil rights. And you say, well, fine, I'll go ahead and buy it anyway. So I don't see that as happening. We did meet with the Mineral or Wyoming Mining Association and the geological and archaeological people to make sure that this was okay with them. They were all very receptive to it and said everything that we have in here they supported. I would recommend your favorable vote on this. And with that, I will stand for any questions, and I hope I can answer.
Thank you, Senator Cost. We're on the amendment. Senator Hicks.
Yeah, Mr. Chairman, just when we get to the standing committee amendment where it brought in the, on page 2, line 15, it brought in the word coal. I just wonder if there was any discussion amongst the committee at the time whether we should want to also exempt members of the Wyoming Senate from that provision also. But just wonder, Mr. Chairman.
Okay. Appreciate it. Oh, Senator Scott.
Mr. Chairman, I've got a request I'm a little embarrassed about, but Mr. Chairman, I cannot access the amendments via the computer. I've not been able to on this one. Is it possible to obtain a hard copy of this amendment?
Thank you, Mr. Chairman. The reason we brought this bill is to avoid future litigation. And, Wyoming's pretty silent on where these fossils belong. And as you all know, we have 2 estates and 2 interests that we have in Wyoming. You have your surface estate and your mineral estate. And we know that those can be separate. Some people own both, but oftentimes we have a split estate situation. And anytime we tinker with that, it's contentious, it's sensitive. And so what we've done with this amendment is try to make it crystal clear that we're not creating a new fossil estate. And if you take a close look at how it reads right now, my concern was that somehow you could sever a fossil right that would be separate from the surface and the mineral. And so in visiting with the bringer of this bill, we talked about whether or not those fossils could be removed from the surface estate and transferred to the mineral. And we thought that would just add more confusion than it was worth. And so Wyoming had to borrow some law from our neighboring state to the north. So I think these amendments really make it clear that the fossil belongs with the surface when those are transferred through any conveyance. And so to the senator from Baggs's point, certainly if he wants to bring a clarifying amendment on second reading, I think that'd be appropriate. Thank you, Mr. Chairman.
So if it's federal, if it's state,
Federal, yeah, whoever owns the surface, correct. And it's just clear.
Still on the amendment, is there further discussion on the amendment? Question, all those in favor of Senator Cost's motion that when the committee, to adopt the committee of the whole amendment number 1 to Senate File 88, say aye. Aye. All those opposed, no. The motion carries. The amendment is adopted. We're back on the bill. Is there further discussion on the bill? Senator Furphy.
Thank you, Mr. Chairman. Let me ask, is there liability then if we pass this bill to the drilling companies if they damage an artifact that's buried they don't know about? Can the landowner sue them for destroying that artifact? Thank you. Mr. Chairman, I do, and it's related to the question that was just asked. And I've been trying to, I think this is a good bill, but I've been trying to figure out, make sure we haven't got unintended consequences here. Some of these minerals, and coal is a perfect example, but I think it's true of oil on occasion as well. There's fossils that are part of the mineral estate. And I know it's true in coal. You can get fossilized, very nice fossilized fern leaves and things like that sometimes in the coal itself. This doesn't interfere with any of the mineral companies that do have access to that mineral estate and may mine mineral that includes the fossil, does it? And I would like to be reassured on that. And I think the principle is somewhat the same as was mentioned earlier in terms of suppose you accidentally drill through one.
Thank you, Mr. Chairman. To refer to the drilling and the activity there, and then I'll refer to the fossils as well. To refer to the drilling, as drilling takes place, they've already said in their testimony and talking with us that once, if they come across anything, they automatically are required to stop and to have that investigated. They say it's very rare when they're in the areas they're in to come across something. And we're not talking about little stuff. We're not talking about a little fossilized leaf or a worm or stuff. We're talking about substantial stuff here because obviously we can go out pretty much anywhere and find a little piece of petrified land or whatever. This is the more material things. As for the fossilized, obviously coal comes from that. But at the same time, we have talked with the mineral group and all, and they say there's no problem. And we've also, through the interpretation with them, you don't find a whole dinosaur or a part of a dinosaur in the fossilized area. That's just not where they're going to find it. The thing we have to make sure of is that we have a lot of fossils in the state of Wyoming, and it's important for us to make sure those are protected for the landowner and not disrupted in whatever way. So this bill does protect that for them. The drilling or the coal, obviously the coal industry and what they do, they dig the ground up. They're going through that strata. Anytime they find anything, they're to stop immediately and have it investigated as well. If it's burial things, human artifacts, whatever, then it goes through the complete 7, it was, got to make sure I'm saying that correctly, 7-4-106, which is the human artifacts burial. So does that answer?
Senator Cole.
Thank you. Would the same hold true for Trona on those protections? Because I know for a fact that they do find large fossils in the Trona mines at times, impressions, things that fit this. Just wanted to throw that out, question, Senator Collins.
Thank you, Senator Kolb. Senator Cost.
Thank you, Mr. Chairman. To the good senator from the largest Trona in most of the world, good question. At the same time, the Trona people were present at our discussion of this, and they said they didn't see any problems with it. If they come across something, they're aware of that and stop it. Most of theirs is underground, quite deep, and so their surface mines, they do have surface mines that they work on at the same time, but they didn't see it as an issue in their discussion.
Thank you, Senator Cost. Senator Ellis.
Thank you, Mr. Chairman. In the court case that kind of prompted the need for this bill, the court did a pretty exhaustive look at trying to understand the definition of what was included in a mineral and whether or not that would include something like fossils. And so the court adopted a kind of a plain common sense approach to how it would interpret minerals, but it did rely on Wyoming statute 3511-103E Romanet 2, which talks about the definition of mineral to include coal, clay, stone, sand, gravel, bentonite, scoria, rock, pumice, limestone, ballast rock, uranium, gypsum, feldspar, copper ore, iron ore, oil shale, trona, and any other material, and this is the important part, removed from the earth for reuse or further processing. And so in identifying that the fossils should be included in the surface estate, it really kind of hinged on that last understanding that once you excavate these bones and other remains from dinosaurs and the like, that there really wasn't a purpose beyond that. You were taking those out of the earth to study them, to have some scientific value, but you weren't throwing them in a coal processing plant or anything like that. So hopefully that addresses some of those questions.
Thank you, Senator Ellis. Is there further discussion? Are we ready for the question? All those in favor of Senator Ellis's motion that the committee hold rise and report, to do so with a favorable recommendation on Senate File 88, say aye. All those opposed say no. Motion has carried. The Senate File 88 is passed committee of the whole. Next bill for our consideration is Senate File 76. Will the reading clerk please read the Senate file?
Senate File 76, Broadband Development Programs Amendments, an act relating to the Broadband Development Program, sponsored by Senator Dockstader. Was referred to committee number 7, which returned to committee recommendation that it do pass amended. Ayes, Senators Boner, Driscoll, Nethercott, and Scott. No, Senator Case. Senator Driscoll, Chairman.
Thank you. For the reading of the bill, Senator Driscoll, what's your pleasure?
Mr. Chairman, I move that when the Senate rise and report it, do so with a favorable reading on Senate File 33. And for further explanation, I ask you to call on Senator Ball.
Did you say 7? Did you say we're on 70? I think you need to say 76. We're on 76.
Oh, I'm off one. Excuse me. I gotta look what it is now.
Well, it's the broadband bill. Mr. President.
Chairman, absent objection, could we lay this back? I've been working on some other matters and I would like to have that laid back on the board, absent objection.
We've got a request to lay it back for one day or?
One day would be good.
Without objection, it is so ordered. Next bill for our consideration is Senate File 33, Physician Assistance Amendments. Will the reading clerk please read the bill?
Senate File 33, Physician Assistance Amendments, an act relating to physician assistance, sponsored by Senator Baldwin. Was referred to committee number 7, which returned to committee recommendation that it do pass amended. Ayes, Senators Boner, Case, Driscoll, Nethercott, and Scott. Senator Driscoll, Chairman.
Heard the reading of the bill. I think, did you finish, Randy?
Yes.
Okay, you've heard the reading of the bill. Senator Driscoll, what's your pleasure?
Mr. Chairman, I'll do it this time right. I move when the Senate rise to report it, do so with a favorable recommendation on Senate File 33. And for further explanation, I ask you to call on the good Senator Baldwin.
Thank you, Senator Driscoll. Senator Baldwin, you'll handle the explanation. Also, there's also a standing committee man. Will you handle that as well?
Yeah.
All right, thank you. Senator Baldwin.
Thank you, Mr. Chairman. There is an amendment. If we can have that read in, we'll work on that first real quick.
Senate File 33, Standing Committee Amendment number 1, page 1 after line 6, insert.
Thank you. Senator Baldwin.
Thank you. I would move that amendment. We'll talk about that first, but before we talk about that, I want to make sure that I make it clear that when we vote on this one, I will be declaring a conflict. I don't find any benefit to me. I wish I found benefit in things more for me, but there is no benefit for myself personally in this bill. It does coincide with my profession, which I'm in the works of winding down. Will be retired shortly, not near soon enough, but I will be declaring a conflict when we vote on this bill. That being said, this amendment first is a clarification. This is brought by the Medical Society and the Medical Board, and it's a request to identify and provide some means of identification of the licensed practitioner. If you want to look at that, and I apologize for looking down here. If you read through that amendment, essentially what it does is provide a means that the PA, the physician assistant who's working, has a plaque that identifies what his license is, that he is a physician assistant, that it identifies a license held, and the advertisement shall be free from deceptive or misleading information. There's a consideration that we may consider this for more practice acts than just this one, but we felt it was important to get it in this one since we have it open now. A person practicing medicine, a physician assistant, shall conspicuously post and affirmatively communicate to the patient the license held under this article. Posting and communication shall include, and then it gives a list of what that includes: a name tag, and a photo identification, recent photograph, as we all change and lose hair through time. That was a joke. Includes the license holder's name, and you can read through that. It's pretty straightforward. Sworn in a conspicuous manner so as to be visible and apparent to the patient. And then it goes on to say, in a conspicuous place in the office, that there's the license, the medical practitioner's license. And essentially, we're just making sure that it's available to the patient to be able to see what this practitioner is. The practitioner is not an obstetrician. The practitioner is not an optometrist. He is what he is, or she is what she is. And I would ask for your consideration of this. I say you'll probably be seeing this similar amendment in other practice acts as we move forward. But I think it's a good move forward, and it amends the bill that we'll go through in a minute. Just making sure that folks know what they're going to. I was given the example, and I'll just give that to you straightforward. If somebody had a knee surgery, went to physical therapy. In the process of going through physical therapy, they were seen by a number of people. None of them had a name tag on. She had no idea what those people did. One was a physician assistant aide. One was a practitioner in physical therapy. One was a physical therapy aide. One was actually a mental health worker to make sure she was mentally stable from the surgery. But she didn't know who any of those people were. For all she knew, they were all doctors or they were all physical therapists. This identification is a way of alleviating that. If you go into a doctor's office or a PA's office, you know that if somebody comes in with scrubs on with a stethoscope on, you say, oh, there's the nurse. Well, maybe it is, maybe it isn't. An ID tag alleviates that. I've been called a lot of things in my career. Some of them not so good, but this is a means of clarifying, of transparency, and we thought it was very important to the bill. So first, before we go any further, I would ask for your approval on this bill and ask for the question on the bill or comments. And yes, I used to have hair. That was probably my computer making that noise. I apologize.
Mr. Chairman, we can't hear you.
Can you hear me now?
Thank you. I have my microphone was off, Senator Anderson. The amendment was adopted. It was a favorable vote. So we're back on the bill. Senator
Okay.
Baldwin.
Thank you, Mr. Chairman. This bill comes to us by way of the state physician assistant. I'm just going to say PA if it just takes less time. And besides that, I'll get tongue tied. The PA organization in the state. This is part of a national agenda. There's 5 states right now that have made this change or similar change. The state to the west of us is actually in the same process. They're a little bit ahead of us. It's actually passed one body and is now in the other body. It's a national agenda trying to free up and make PAs more employable, make them more available, and ultimately to help the patients out, particularly in rural access areas, critical access hospitals. As it stands with the PA tied to the physician license, it makes it difficult for that PA to be employed. A lot of hospital administrators, a lot of physicians, frankly, forego hiring a PA as it becomes much more administratively difficult and much more difficult to bring a PA into your practice. The PA model across the board and historically for the 50+ years that it's been in existence is to work a teamwork with the PA and with all the medical team, the physician, with the DOs, with the physical therapist. It's considered a team process, and this bill doesn't change that. What this changed is it makes the PA a practitioner that doesn't have to be tied to the physician license to practice. Just a little bit of an introduction on the education of physician assistants, and that's changed through the years. Initially, physician assistants came back from a war as Navy corpsmen. They came back from the war. They had no place to practice. They had an incredible set of skills, a very advanced physical and surgical skills, and had no place to practice. They came back into society, no place to use that skill. This model was developed, and it was developed so that they worked with a physician. Since that time, it's evolved. Physician practitioner or physician assistant education now includes a didactical portion where you go sit in class, almost always associated with a medical school, not always. Mine particularly was associated with the University of Utah. After that didactical, they go through a series of clinical processions. That may include obstetrics, it may include surgery, it may include a number of things. Orthopedics, they're not all exactly the same across the nation. They're a little bit different. But it also provides hands-on patient care. Typically, that's about 3/4 of the education is actually getting out and doing the work. PA standards are very high. They take a national certification called the NCAA-PA. They have to pass that certification board, and after passing initially every 10 years, they have to do it again. Also included is every year they have to pass 50 continuing medical educations. So every 2 years, they have to recertify having 100 CMEs. The test that they test every 10 years is not an easy test. Most people will tell you they have to go take a course to prepare for it. It's a very difficult test. It tests their skills and their knowledge dramatically. Physician assistants have worked continually as a team member with the team and the medical team. And you'll find, and several of you will know that, it used to be able to have a doctor's office. They all had their independent offices. That's evolved into a system now where most of those physicians, not all, but many of them have moved into a hospital or a clinic type practice. So physicians aren't so much out on their own in an office. That fit the PA model more closely because a physician could hire a physician assistant and expand his practice or her practice and become much more profitable. As they moved into the clinical and hospital, that model has changed, and hospital administrators are a little reluctant to hire someone who is not an independent practitioner or not licensed as such. Well, that's one of the things that this bill does is make it possible for physician assistants to be an independent practitioner within the medical model, working with the team. So with that all said, let's just walk through the bill real quick. It's an easy bill to walk through. It's not more than 100 pages long. The first thing is, and this caught my attention when I first looked at this, when this was brought to me, is that the first thing you see changed is PA physician assistant. It attaches the title right there in the first page. The first change you see is the ability to practice medicine. I will tell you that when I first went to work, when I came out of school, my license said, Fred Baldwin, physician assistant, is licensed to practice, and then it had medicine, but it was crossed out. I was licensed to practice in the state of Wyoming. I don't know what I was practicing, but it wasn't medicine. And this bill does correct that, is that the physician assistants are licensed to practice medicine. And that's the first couple changes in the bill. And then the substantial changes begin on, in mine says page 3. I don't know what it is on there, but it's the page where the substantial changes start. This article does not apply to persons enrolled in a physician assistant education program. In other words, they're not licensed early. This doesn't apply to them. This applies to people who are already educated. And then if you walk your way down through this, a physician assistant is an individual who practices medicine. And then we just take all this supervision and all that supervision signature requirement out. A physician assistant is qualified by the individual's education, training, and experience to provide a broad range of diagnostic, therapeutic, and health promotion and disease prevention services. And then there's just some language changes. You'll see these language changes are mostly separating away from the physician license and allowing that physician assistant to practice in what he has been trained in or what she has been trained in. The training is vigorous, and it's very important that they be able to operate and be able to practice at their full practice potential and what they're able to do. The last part of that says collaborate with, refer to the appropriate member of a healthcare team as indicated by the condition of the patient and the education, experience, and competence of the physician assistant and current standards of care. I will tell you, any patient that I see, I collaborate down the hall, I collaborate down the street, I collaborate in another town, I collaborate in another state. This bill doesn't change that. And I think if you talk to any physician assistants in your local communities, they will probably all tell you the same thing. They collaborate as part of the team. And that's the way the PA is trained, is to be part of the team and collaborate with others. This bill just makes it easier for us to do that. It makes it easier for those, those rural hospitals, those critical care hospitals to hire PAs and make them more available out in especially the rural areas. And the important at the bottom of that big last change, the degree of collaboration shall be determined at the practice level. We talked about this a little bit in committee. And that determined at the practice level, and in other words, the hospital, the employer, the group, the credentialing body, whoever, they need to work with a physician assistant and decide, what the degree of collaboration is. Do you want them to work with a physician? Do you want them to work with a nurse practitioner? Do you want them to work with another physician assistant? That needs to be determined at the local level rather than having this overbroad thing. And then finally, the bill just, after separating all the physician licensing things out, at the very bottom of this talks about a board, a physician assistant advisory committee to the Board of Medicine. And then it just lays out what that would consist of. The majority of the members of the advisory committee shall be physician assistants, as opposed to the advisory committee to the Board of Medicine that's in place now, requires that there's 2 members shall be physicians. We're just changing that. The advisory committee, the majority needs to be physician assistants. Not to say that there can't be physicians on that advisory committee, but we want to make sure there's a substantial number of physician assistants who are aware of what's going on. And finally on the bill, almost finally, we're at page 99 now. No person shall practice as a physician assistant or represent oneself as a physician assistant without a license granted by the board. The part of this, another important part that doesn't change, the physician assistant is licensed by the Board of Medicine. They practice under the rules of the Board of Medicine, and that absolutely doesn't change. That stays the same. And then the final piece of this is the prescription authority. Right now, physician assistant prescribes medications, including these listed on that last page there. Schedule 2, 3, 4, and 5 drugs. Those are controlled substances. That's your cough syrup, that's your Lortab, that's your Ambien, that's your Valium, that we could all use some. That doesn't change, but right now that's tied to the physician's license. But each individual physician assistant who wishes to have one has a DEA, a Drug Enforcement Administration license. So that doesn't change. They'll still have their individual number and they'll still prescribe drugs. They can't prescribe class 1 drugs. Very few people can. It's a special license. Even physicians can't prescribe a Schedule 1 drug without special authorization from the DEA. And the other thing, excuse me, the one other thing that's included that physician assistants can do now and will be able to do after this bill passes, hopefully, is to dispense prepackaged medications in little communities. And I don't know all the little communities. I'll just use Cokeville as an example, which is in our county. Sometimes there's not a practitioner there. And when there is, it's a physician assistant. And they've got prepackaged things like a week's worth of amoxicillin. They're allowed to dispense that package of amoxicillin because they may not get to a pharmacy for another week because it may be snowy. They may not be able to get there. So this allows them to do that when they're out in these very rural locations. So with that said, I say the thing that this doesn't do is it doesn't change the practice of a physician assistant. It just makes it easier for them to be licensed and makes them a more available person to the healthcare team. And ultimately it benefits the patients, particularly in the rural areas of the state, which right now are having difficulty hiring. It's hard to find a physician that wants to take on that extra burden of the physician assistant and the extra administrative duties that entails. Most physicians assistants, incidentally, have their own malpractice insurance. That doesn't change either. There's 2 malpractice agencies or companies in the state that insure most of the practitioners in the state, and that wouldn't change. not only would it not benefit most PAs, it's going to mean a little bit more out of their pocket because they may have to pay that instead of the hospital or the doctor paying that, helping pay for that malpractice. Now they may have to pay their own. But with that said, I will sit for further questions or comments.
Thank you, Senator Baldwin. Is there any discussion on Senate File 33? Discussion or questions on Senate 33? Ready for the question? All those in favor of Senator Driscoll's motion on the committee of the whole rise and report that it do so with the favorable recommendation on Senate File 33, say aye. Aye. Those opposed say no. The Senate File 33 has passed committee of the whole. Mr. Majority Floyder, with your leave, I think we'll take a, if we can, we'll stand to at ease to the sound of the gavel for about 10 minutes to take a little break. Is that okay with you? Okay. Thank you. We'll stand at ease to the sound of the gavel, which is about 10 minutes. Thank you. The next sound of the gavel. There you go.
The committee of the whole will please come to order. Senate File 79. Okay. The next bill for our consideration is, do we have a quorum? We have a quorum. The next bill for our consideration is Senate File 79. The reading clerk will read the bill.
Senate File 79, Medicaid Billing for School-Based Services, an act relating to school finance, sponsored by the Appropriations Committee, was referred to Committee Number 2, which returned to committee recommendation that it do pass amended. Ayes, Senators Grew, Hicks, Kinsky, Perkins, and Steinmetz. Senator Perkins, Chairman.
You've heard the reading of the bill. What is your pleasure, Senator Perkins?
Thank you, Mr. Chairman. I move that when the committee of the whole rise to report that do so with a favorable recommendation on Senate File 79, Medicaid billing for school-based services. Mr. Chairman, this bill is actually an outcropping or an outgrowth of the Efficiency Commission that we did was a legislation that happened in 2017 that we hired some consultants that came and looked at a number of ways to try and either save money, obtain more money, or find more efficient and more effective operations throughout state government. One of the recommendations that they made that has not been acted on yet is receiving Medicaid reimbursements from the federal government for Medicaid services that are offered through our special education and individual education plans that we have for some of our special needs students. The consultants who when they did this report in 2017 and 2018 found that the state receives approximately 1.2% of its funding from special education funds, which is well below the average of about 1.9% from IDEA grants, which are grants from the federal government. Currently, the state reimburses 100% of federal education costs in accordance with state statutes, and these funds have grown faster than the districts. And so what they found out and what they're telling us is that out of the 50 states, Wyoming is the only state that doesn't receive Medicaid reimbursements in education funds. And so we had these folks look at that, and they came up with what they thought were some estimates that could be done if we just had the funding that was roughly equivalent to some of our exemplar states like our sister states of North Dakota, Idaho, South Dakota. They looked at a number of those states and found that they were receiving millions of dollars in Medicaid reimbursements to help offset the costs for Medicaid funding that we are paying 100% for out of our school funds, particularly the School Foundation Program. So anyway, that what this bill does is it goes back and takes on the consultant's recommendation that we change a couple of statutes and begin to work on this program. I can tell you that the education consultants thought that with this, with probably an investment of somewhere around $350,000 to $500,000, that the state could eventually or could realize a biennial savings of between $6 million to $12 million. While I think the Department of Education looked at this back at the same time and in October 25th of 2017, wrote a letter and basically concurred with those recommendations that was available out there. Since then, the Education Committee and some other committees have looked at some of this and found out that the number's probably not that high, but that there are still some savings to be had. And the question will be, what does it look like? And this comes into the fact we have to also take into consideration, there's been a lot of concerns about the fact that if we do these waivers because of our maintenance of efforts funds, we may not be able to recover some of that as rapidly as we want. But one thing we worked this bill, and what this bill does is it starts this process. And so if I go into an explanation of the bill, and there are two amendments, and we'll get to those kind of after we go through the bill, so we kind of understand what the bill does in its base form. It goes into 2113-321, and you see it just changes. What we're doing here is in talking about the amount provided for special education within this education resource block grant model shall be equal to 100%. None of that changes. But when we talk about, when you get to line 8, for special education programs and services, which shall include the amount actually expended by the district during the previous year for reasonable administrative costs to bill for authorized Medicaid services under subsection H of this section. What we're trying to do there is just grab, you can receive not only some of the Medicaid services and be reimbursed for the services that are actually provided, but there is some ability to also recover an amount to help with the administration of that program. So then what we have down below to start this program off, beginning July 1st of 2022, each school district with 25 Medicaid or more eligible students receiving receiving special education programs and services, what they'll do is they may bill the Department for Healthcare costs for special education program services covered under certain particular statutes. And so what we're trying to do in this section, and you can read through what the new language is, but what we're trying to do is that they'll report to the Department of Education. We found that in our testimony that a lot of the schools are using software that already have most of these Medicaid items are already covered in the software that they have. It will take some training and some other things to get that, but most of the information that's needed to fill out these forms is already available. And we just have to have people be able to understand and how to pull it out of the existing software. The school district may report, and so you see down on line 17 on page 3, it's a may report the number of Medicaid eligible students receiving special education. So it was trying to go through. We've had in the past year, we've had some school districts said that they would step up and volunteer to start this and see if we can start to realize some of the savings that may be available. Keep that in mind that we'll come back and talk about that in one of the amendments later. Then you go to page 4 and you see the types of professionals, the types of services that are authorized by medical assistants under this chapter. These are medical services that are provided to students who are usually special education students in our school districts. So you have the list there of the different types of preferred services that we may be able to, and we can seek authorization or we can seek medical reimbursement for. And so then section 2, we get the director of the Department of Health with the consent of the governor shall negotiate with the United States. So the Department of Health is going to go back and they're going to make the necessary amendments to the state Medicaid plan or make another necessary waiver that will enable us to then qualify under the waiver that we have, that every other state has, that we don't have yet, to be able to recover some of these Medicaid dollars from the United States and help us to cover those costs here in the state of Wyoming. So section 2 authorizes and directs the department to go back and seek what they need in the form of modifications to the existing Medicaid plan or any other necessary waiver. And then also, then you see down in section 3, it's going to take some people and some expertise to do that. So we start some appropriations. Those are going to change in the amendment. But with that, that's kind of the basis of the bill. When we, what the amendments do to change the structure of that bill, at this time, I'd like, if we could, Mr. Chairman, to read in Standing Committee Amendment number 1 to Senate File 79.
Will the clerk please read the amendment?
Senate File 79, Standing Committee Amendment number 1, page 1, line 5, delete.
Senator Perkins.
Thank you, Mr. Chairman. Mr. Chairman, I'd move Standing Committee Amendment number 1 to Senate File 79 and ask unlike some of the other Standing Committee amendments we've had today, we're going to ask you to vote for this one. So what this amendment does, and this was actually an amendment that was recommended to us by the Department of Health and their folks, that they came and talked to us and talked about a little bit about some of the practicalities of what they thought and how this program should move forward. So this does a couple of things. What this mostly does is it starts to, this amendment does a couple things. It goes in, and one of the first things that it does is it's going to require reporting. The way this is structured, it's going to set out for the first 2 years. It's going to be kind of, we're going to allow the department and the schools to kind of ease into this. They're going to go out and they're going to work with, we're going to work with not just school districts that have 25 or more eligible students. They're going to go out and find those who are receiving a serious number of Medicaid services that are reimbursable. So we're going to, basically, the department's going to go out, work with the Department of Education, Department of Health, and local school districts and try and identify the most obvious and most expensive cases. There are cases where you have one child that may receive in excess of $100,000 of Medicaid services in any given year was an example we got, that may be at a small school district that might not have 25. And you might have another school district that had 25, but none of them receives more than a few $1,000s of services in a year. So they wanted the opportunity and then some flexibility during the first 2 years to go out and explore this and find out if we could, two things. One is how much, what is it that we can find and expend that is reimbursable to the state, and what that looks like before we jump off and do this full blown to see if this is cost effective and worthwhile to do. And they thought that the department thought that the 25 minimum number before any school district was probably nonsensical, but they did believe that there would be school districts that have less than that there would be significant reimbursable dollars, and school districts of 25 or more that there would not be significant reimbursable dollars. But they wanted the opportunity to explore that and develop that together. And at the same time, they believed that trying to implement this program in the course of a year was just, it was undoable. It was just too much. It was too heavy of a lift. And so they wanted the opportunity to ease into this. I think there's some people, the folks that have come to talk to this, I've had respect with, these are some young people that are just outstanding people in the Department of Health. And I think that when they come and talk to us, particularly a couple of these witnesses that we had, I have a tendency to listen to them because I think they've done a great job in trying to help manage the Medicaid and Medicare funding and the healthcare financing sections of the Department of Health. I think they've done a good job. And so we ultimately as a committee thought that we should do that. We should accept their plan and let them work and see if we can get this thing to work and see if we can reduce, if it's $3 to $5 million in the first year, it's still $3 to $5 million of taxpayer dollars that we're going to have relief from, that we don't have to find in some other place from the existing revenue sources that we have. So that's basically what the first number of lines do, probably down through line 18. Then I think when you go to the rest of the amendment, what it does, it goes back into the appropriation. They gave a hard look at both the department, visited with the Department of Health and the Department of Education about what they needed to be able to find to do that. They believe that these appropriations will be primarily used for consultant types to go out and both, this particularly right now, it's the experts that have this education. They're doing this. They've got the software that's being used to do this has already been deployed in our sister state of South Dakota. And so they're doing that. They've implemented that throughout South Dakota with some software to help enhance what they're already doing. Those people now they anticipate probably hired to come here. That software has already been deployed through a number of our local schools here. And there's a software model inside that can help do this. And so it's that we have a lot of the capability already exists in a significant number of the school districts around our state. We thought that sounded logical. We wanted to give them the ability to do that. And so this is an investment to see if we can, if we can do that, you see the investment there, the appropriation is a little bit more. It appropriates $142,622 from the school foundation program to help pay for that. And then because it's a Medicaid, there's also a Medicaid match. We can have a matching grant from that of federal funds of an equal amount to do that. And so that as we come and pull that in, this is the money and the positions necessary to go see if we can get this done and do it right. At the end of the day, if we come back and we'll monitor this program going forward, it doesn't work, we'll pull the plug on and end it. But it's one of those things that potentially, I believe from my work on the Efficiency Commission, that this has potential to be tens of millions of dollars if we get a decade or two down the road, tens of millions of dollars that of federal funds to come and pay for what state funds are paying for now. So with that, Mr. Chairman, I'd stand for questions on the amendment at this point, and then we'll get back on the bill and we can answer questions about the bill as well.
Thank you, Senator Perkins. Discussion on Standing Committee Amendment number 1. Senator Scott.
Mr. Chairman, on the amendment, am I right in reading the amendment that the appropriation is entirely to the Department of Health and not to the Department of Education or the school districts?
Mr. Chairman, I think the amendment is probably necessary to do this. It's complicated.
Any further questions or discussion? Senator Cooper?
Yes, sir. Thank you, Mr. Chairman. For the amendment, I didn't understand, I didn't listen fast enough to understand where we were on the 25 students. With the small schools, in my district, I got 5 schools that 5 school districts that wouldn't have 25 special education students. And I just want to make sure that we're not going to preclude the small schools from this program.
Thank you, Senator. Further discussion or questions? Senator Rothfuss.
Thank you, Mr. Chairman. One follow-up also on the reporting and a concern with the phrasing. The Education Committee over the past decade really has worked pretty hard to try and reduce the number of reporting requirements on school districts. And because of the fact that honestly, we've overwhelmed them with reporting and a lot of it's federal requirements that we haven't been able to ease back. But that's been a heavy focus because everything sort of gets rolled upward. So every school ends up having to fill out a report that goes to the district. The district provides the report. It's amazing how many hours end up going into any one little question they're asked to file. So as we look at this and contemplate moving forward, we always want more data because more data helps us in the legislature. But I want to make sure that we're not putting something that's onerous on the districts that, and getting back to the good center from the center west part of the state, where we've got some districts that might have one person, or perhaps 0 that might be Medicaid eligible. Was there discussion about trying to balance those interests where we're not putting an onus on districts that wouldn't be likely to participate in the Medicaid sharing program because it wouldn't necessarily be in the interest of administrative savings or state savings to do so. And I'll stop there. And that gets at the amendment specifically because of the kind of shall that goes forward, which is a little different from the first draft. So thank you, Mr. Chairman.
Senator Perkins.
Thank you, Mr. Chairman. Yes, so going back and answering the questions, we'll start with the easiest one first. And so that the amendment actually deletes the reference to 25 or more. And so that's gone. So no school district will be precluded from participating. And the reason that that amendment was adopted was, as we received testimony, was that there are some students that have 25 or more that just don't spend very many Medicaid dollars, and it's just not worth chasing. It's not worth it. And so, on the other hand, there are school districts that may have just a few, but they may be very severely, they may be severely disabled, and they may be receiving substantial Medicaid dollars. And so, the object was to work with the Department of Education and the Department of Health and the local school district to identify, I hate to say it, but basically that low-hanging fruit, to identify where this is and where we could benefit from this. So it's not to go out and impose this reporting requirement and do all this immediately. So what we're doing is giving us the balance of the biennium, basically the next 2 years, for the department to work this out and figure out what this should look like, find and select students and districts to work with where this looks like it would be cost effective to do so, and then begin to implement that. The amendment does say that after 2 years, it does become mandatory for reporting, but we'll have information back and we'll know whether or not it should become mandatory in 2 years. So the mandatory reporting for all districts starts in 2 years, but we'll have information to know before it does become mandatory. And if we need to scale this back, we can. But the point is, for these first 2 years, is to ease into this, both to find and identify what that looks like, and then to start to explore and see how it works. And if this is unsuccessful, if it's not cost effective, I'll be the first one up here to say, let's pull the plug on this. It was worthwhile to do it. The other thing that was interesting as we talked about this, I'm coming back to the one question. Yes, all the funding does go into the Department of Health, and because they anticipate that they'll be hiring again, they're going to be outside folks that already know how to do this, already doing this in another state, to come in and they'll help train both the department here, and then when they identify the districts they're going to work with, help them, because they think that one of the things that will be useful in selecting districts is some districts are already using this software. And so most of the information that they'll need for this, for these applications for Medicare reimbursement are already being produced and absorbed and reported for the 100% reimbursement. And so they think with just a little tweak there and a little training that there's not a significant reporting burden that will be in addition for this Medicaid than what they're doing to obtain their reimbursement now. But they're bringing in experts to help understand and know that and monitor that, and we'll see how that works. But there is no additional, I believe that there is no additional appropriation. The amendment changed, so there's no additional appropriation for the Department of Ed. It's all the Department of Health, and basically in their Medicaid financing. And they've identified these people and think that, I've visited with them, they think that they can get this done for the amounts that they've talked about in this amendment.
Further questions or discussion on Standing Committee Amendment number 1? Senator Rothfuss.
Thank you, Mr. Chairman. Mr. Chairman, I do have some concerns with the amendment, although I have concerns with the original language, and I appreciate some features of the amendment that try to address that. I think it's absolutely the case that a simple number of 25 students is less useful than just looking for students that would be the high dollar students. There's no question that that's an appropriate approach. But at the same time, when we took testimony on this in the Education Committee, this was not necessarily the most sophisticated analysis, but we concluded that probably 5 or 6 of our 48 school districts would be net profitable, and it would be workable for them, the larger districts, most of the time. And that is, of course, accepting the fact that we will have some students that are the $200,000 a year students that we could bill Medicaid for. So the challenge that we faced when we were considering it on the Education Committee was always based on the administrative cost for small school districts, where it seemed that the larger districts were using appropriate software, were sophisticated, they had full-time personnel. And so the idea that we would tack on an additional task, and that's effectively what this does, is provide let us know how many Medicaid eligible individuals there would be. That would be something that would be doable for these large districts. But when I contemplate districts that are smaller or smallest in the state, Mr. Chairman, in your neck of the woods, tacking on this additional workload might be significant. They might have to struggle to find somebody who's going to do some half-time FTE additional work because they don't know intuitively necessarily which of the billings that they send to the department for reimbursement are or are not Medicaid eligible, to my knowledge, unless they've got some more sophisticated software. So, Mr. Chairman, I'm actually going to support the amendment, so on and for the amendment, because I think it moves us in a better direction than the previous language, but I don't think it's there yet. I think it needs a little more work, and I don't know if 2 years is going to be enough to get our smaller districts to the point where they could actually accomplish this without a significant additional workload at a time when it's more likely that we're going to constrain their resources. So I'll support the amendment, urge the body to support the amendment, but I'd encourage the proponents of the bill to maybe figure out if there's a better way that we can ease it up on the smaller districts. I'm not worried about my district, for example. I think we'd be fine. But some of the rest of the good senators' districts might be a little bit challenged on this one. Thank you, Mr. Chairman.
Thank you. Further discussion or questions on Standing Committee Amendment number 1, Senator Scott?
Mr. Chairman, I too urge you to adopt the Standing Committee Amendment. I do have a concern here. Frankly, I don't think this is as much rocket science as being made out to be. 49 other states have found this to be profitable and are doing it on a collective. My understanding is the child development centers all across this state are billing Medicaid successfully, because it pays them. And yeah, it's helpful to have some software that does it. It is a nuisance. Medicaid makes it difficult to operate with it, but everybody else seems to be able to manage it. And now, in the part of it where you're, Mr. Chairman, where we're appropriating money to the health department, because they've got to deal with CMS, we may have cut them back enough so that they really do need the help there. That's going to be a real complication. And when we get back in the bill, I'll talk a little bit about that. But I really am skeptical about the resistance we're getting from the education community. I do think it's going to be, getting this done is going to be a good deal simpler if we aren't looking for ways to make it complicated.
Yeah, Mr. Chairman, and just to kind of highlight some of the testimony that we have compared, I think it was 5 or even maybe 6 years ago that the Joint Education Committee looked at this. Fast forward 5 years, the testimony that we received, it's somewhere near the neighborhood of maybe 80% of the school districts in the state of Wyoming now are using the same software that's available. And it didn't seem to be like it was going to be that much of a burden. But that's the reason this is phased in. The first year it's voluntary. And the reason to do that is to find out, to make sure that we're able to effectively train, that we don't put an inordinate amount of burden on the small districts or any district from that. And I think that gets to my colleague from Natrona County is with the testimony that we had is with the software that's available today, this is not going to be a burdensome task on the school districts, whether you're small or large. It's phased in over 2 years to give them the opportunity to do the training and work the bugs out to make sure that it's even less of a problem for those smaller school districts. So I think things have changed since the Joint Education looked at this 4 or 5 years ago, Mr. President or Chairman.
Thank you. Further discussion on Standing Committee Amendment number 1. Question having been called. All those in favor of Senator Perkins' motion to adopt Standing Committee Amendment number 1 to Senate File 79, please say aye. Aye. Those opposed, no. Motion carries. You have another amendment, Senator Perkins.
Yes, Mr. Chairman, this next amendment was, so I would ask that the Standing Committee, the Committee of the Whole Amendment number 1 to Senate File 79 be read in.
Will the reading clerk please read the amendment?
Senate File 79, Committee of the Whole Amendment number 1, page 6, line 1, in.
Senator Perkins.
Thank you, Mr. Chairman. I'd move Standing Committee Amendment number 1 to Senate File 79 and ask the body again to vote aye. What this says was just brought to us by staff. They just identified that we had not restricted this appropriation, that this appropriation could only be used for these purposes. And so that's what this does. This appropriation is limited, that it can only be used for this purpose and it can't be absconded or sent somewhere else. So that's what this amendment does. Would ask for your stand for questions. If there are none, I'd call for the question.
Any questions or discussion? Hearing none. All those in favor of Senator Perkins' motion that Committee of the Whole Amendment number 1 to Senate File 79 pass, please say aye.
Aye.
Opposed, no. That amendment carries. We're back on the bill. Further discussion. Senator Scott.
Mr. Chairman, this is a bill we need to pay careful attention to because we're starting to talk real money. I do have a concern with one of the things we're getting into here. This is something that 49 other states have done. This is something our child development centers have done. This is not great rocket science, and they do it because you can get the federal government to put up half the cost. You do have to, there is a complication in here. We have to put up the state share of the Medicaid. It'll run the Medicaid budget up, and then we'll save half of what it runs it up because the feds will be paying us to do something we would otherwise probably have to do with the school foundation fund, and in fact, these days, the general fund. You really have trouble distinguishing between those funds in this day and age. Frankly, I think they could do it a lot quicker if they wanted to. It has been easier for the school district to say, well, they pay 100%, we'll just ask the state for it, not bother with the complications of dealing with the Medicaid program, and there are some. And if they're so bad that it's unprofitable for a lot of districts, then we ought to charge Committee 10 to find out what's wrong with our Medicaid program in this particular aspect. I don't think there really is a problem there. I think it can be done quite readily. Mr. Chairman, there is a problem I would like to ask about. As I recall, the federal law specifically says that this money cannot be used to supplant state funding. And we have, the reason we're the only state that's not collecting any of this money has been that with that provision in the federal law there, we have not been eligible. And my question is, does the committee know, is that provision of the federal law still there? I know there was an attempt to find a way around it after we put some kind of a cap on the special education in the school districts. And I've heard there was a workaround, and I've heard concern that that workaround is not likely to be adequate. And we're likely, Mr. Chairman, to get turned down by CMS again over that issue. And one of my questions is, should we accompany this bill by an explicit cut in the percentage that we reimburse the school districts so that we are in fact eligible? And there's some maintenance of effort things that play in here that I know I do not understand. What are the obstacles here to getting the feds to approve it, and can we solve them with a simple budget cut that frankly the school districts could live with for a year or two given the amount of reserves they have? So, Mr. Chairman, I think we need to think about those, but this bill I think is a very important one to pass, and I compliment the Appropriations Committee for getting this thing moving, because it's a disgrace that we have not done it long since.
Senator Landon.
Mr. Chairman, thank you. I do think, by the way, that we probably have a maintenance of effort issue on the last point made, but I just wanted to rise, Mr. Chairman, and mildly push back on a couple of things. One is, I think that we need to be careful comparing our efforts in the public schools with those of the CDCs out there. You've operated in that world, and you know that that's a huge percentage of Medicaid eligible students that we have in those facilities. And so I think that certainly there's a lot more return on investment there. The other caution that I would just throw out there, having served many, many years in public administration, and that is that regardless of what software program you have, you still impact your workforce. And we're going to do that at a time when I believe that we stand a chance to draw those budgets back pretty dramatically. I only say that just as some cautions along the way. And I'm going to support the bill because I think it's worth a try. I just want to throw out this. We're going to talk about lots of things out there in the K-12 system. And I got a reaction yesterday of somebody saying, well, that's just not going to amount to very much money. Well, this isn't going to amount to very much money. I wish it was, but I think it's worth a chance. And there's a lot of things that are worth a chance. So let's just remember not to tell each other every single time that it's just not going to amount to much money. Because if we do that enough, maybe it's going to amount to quite a bit of money. So anyway, just a couple of cautions along the way. We looked at this for a long time on the Joint Education Committee. There are some issues there, but I commend the Appropriations Committee. Let's give it a try. Thank you.
Further discussion, Senator Perkins.
Thank you. There are just a couple of things to address because we did have some testimony on this and some history about this. I know that when the consultants did the original study back in 2017, that we specifically talked with them, the Efficiency Commission specifically talked and quizzed them about a couple things. One of them was the fact that because we reimburse 100%, what kind of problem, and they believed that was not a big a problem as the state thought it was. And so but you know, this maintenance of effort has always been a little bit of an issue. And even if it's in case, I mean, if you never get started at your maintenance of issue, you never start to fund the incremental increases that you otherwise be entitled to with Medicaid dollars, you'll never get started. So if you only save $1.5 million or $2 million in the first little while, was it worth it? Well, probably not maybe in the first, but you know, in 10 years from now, if that's 10 or $15 million, that may be a significantly another story. And that's kind of one of the reasons why I've always been an advocate for moving in this direction. One of the other things that we know is that the special education funding, which includes part of it is the Medicaid services that we're talking about, is one of the faster growing elements of education. Every year it grows. How many of you, when you go to the doctor, think that gets cheaper every year? When you go to your psychologist, when I go to you go to your social worker, does that get cheaper every year? I don't think so. And so this is, these are increasing at about 6%. When we looked at the Efficiency Commission, I remember the number was, they're increasing at about 6% a year. So again, if we never get started, just like my good friend from a little bit smaller height than I am, although it's only about an inch, I've noticed, but my good colleague from Natrona County, he's exactly right. If we never get started, it never will amount to anything. The other thing that we had, which was I found interesting, we had the folks that were testifying are I believe very competent CMS healthcare financing people. He thought that some of the testimony we received is he thought as we went about the waiver that he did not think the maintenance of effort would be as big an issue as we thought maybe it was in the past. That ultimately he thought that the state would be able to make, as they work through their waiver, a very good argument that we're entitled to whatever Medicaid dollars we're entitled to. If it's a Medicaid covered services, we should be entitled to those dollars. And so that it may not be just only on the incremental, but he thought that there are enough dollars that it was worth a try to get started on this and to get started on it now. And that's why we bring you the bill. Happy to work with anybody as we move forward with this. If we can make this bill better, if we can make it more functional, happy to work with anybody to do that. I think the only other thing I would mention is that we did talk about the fact the software is out there, and that we also talked about, he believed that as special districts apply for their special education reimbursements, that they're keeping track of, for example, when the school psychologist comes, if you spend a quarter of an hour, they spend a half an hour with it. They're marking down already whether it's a quarter of an hour or whether it's a half of an hour. They're already keeping that information, and that's already in the system, and that's already available. It is more work to go compile that and make an application and dance and jump through the hoops that you have to jump to get the Medicaid money. But the data itself is already being accumulated, and maybe with a few tweaks, it's and part of this is also to bring the expertise in to get the applications, understand the application process and get that. Because as our good friend, the good tallest senator from Natrona County said a few minutes ago, it's going to work not dissimilar. The districts have to expend it. They have to apply for their reimbursement. They will reimburse them at 100%. Then you apply to Medicaid and eventually you get your reimbursement. So it's you still have to fund that up front, but ultimately we can get it back. And as we're finding, it's kind of like getting some of those FEMA dollars back that we're finding. There's a substantial amount of FEMA dollars that are coming back that's helping with some funds that have been advanced to pay in the current pandemic. So it's it's one of those lessons we learn as we go along, we get smarter. Thank you, Mr. Chairman.
Further discussion, Senator Bateman.
Thank you, Mr. Chairman. My question is on the logistics of the billing and who's going to be responsible. Could the state of Wyoming do this billing on a statewide basis, or are we going to have all 48 districts do their own billing? I'm thinking of trying to get some efficiencies there. Don't see that in the bill specifically spelled out. And does the state already know who's Medicaid eligible? Is this a duplication of efforts? Can we pull this data, and who would do this? And is there a more efficient way to go about it than having each school district basically do their own billing and applications? If the Department of Health could do this for them, that would be great. So that would be my question on the bill. Thank you, Mr. Chairman.
Further questions or discussions? Senator Rothfuss.
Thank you, Mr. Chairman. I wanted to add to that. I think the good senator from Sheridan County is onto a good concept where even when we look at the small districts, if we get to the point where we've simplified and centralized such that a standard billing for special education services has sufficient information for the state to determine which of the billed for activities are Medicaid eligible, there might be a way to expedite that. That's not something that I recall looking into on the Education Committee. I think that's a really solid idea. I'd ask the Senate the Appropriations Committee if they had considered that as well, because it would certainly, again, centralize and decrease the costs. I did want to weigh in a little bit on the idea of cutting districts as a means of providing an opportunity to then have a maintenance of effort consideration that's improved. While what we're doing here might be a challenge from the standpoint of getting a federal waiver and having it be acceptable from the supplant versus supplement concepts and the maintenance of effort, any direct cut is exactly what they're looking for. That's the low hanging fruit, easy down the middle of the plate failure to maintain effort that would lead to an IDEA violation, the Special Education Act, and wouldn't be a potential approach. And the final point, Mr. Chairman, is that one of the reasons why Wyoming is unique in this is the nature of our funding model, in that all of the funding, even though we think of rebate and recapture, but at the end of the day, the state funds education in the state of Wyoming, right? We've got a common funding model and we've got a statewide education system. And so as a result of that, we have a 100% reimbursement rate for special education because all the funding flows from the state out as needed. No other state has a model like that. No other state has a 100% funding model. So every other state has an easy time doing something like transitioning to a Medicaid reimbursement system, since their maintenance of effort is never going to be at 100% as we are. They have wiggle room and we don't. So we do have unique challenges, but the last point, Mr. Chairman, is we have heard recent presentations that suggest that there are ways and there are flexibilities for maintenance of effort if we were to make a waiver application, because the maintenance of effort does not have to be necessarily on a strict dollar basis. It can be on a number of identified individuals basis. It can be on other bases, so long as we are perceived to be maintaining the same level of effort. And honestly, it might just be accepted, as the good chairman indicated, that we're at 100% effort if we apply for a waiver that recognizes that the state's effort will still effectively be 100% of the outstanding balance. There's an argument that can be made that that's a continued maintenance of effort. We might not win the argument, but if we won that argument, that would actually be substantial amounts of money. That would be the best possible outcome. So, Mr. Chairman, again, I'm not perfectly satisfied. I look forward to trying to work with the sponsors and maybe trying to find some ways to improve this, because it's not certainly not perfect, but I don't know that we'll get to perfect. And I do see that there's the possibility of saving some money if we do it right. So on and for the bill. Thank you, Mr. Chairman.
Further discussion, Senator Scott.
Mr. Chairman, in response to the question about should we do the billing at the state level, essentially it almost has to be done locally because you need to be able to associate particular services that were provided, say by a physical therapist or speech therapist, probably would be the most common one. They have to be Medicaid eligible services. And you have to know how much was provided to each student that was Medicaid eligible. So essentially your local districts, and there probably are some opportunities to centralize where maybe a larger district could do the billing for a number of the smaller districts. There's probably, I'm almost certain there's some opportunities there, but they have to bill the state. And then the state pays them. And then the state gets the federal reimbursement from Medicaid for all the things that we do. That's the fundamental structure here. The state is not forwarding bills to the federal government to be paid. The state is paying the bills, aggregating it, and then we get periodically reimbursed by the federal government, is my understanding, is the way it actually works. So you can't have a centralized billing at the state level. The state is the one getting billed. The system we've got of 100% reimbursement, we've made some efforts with the caps that have been put on, that's helped. And but I know there is concern in the executive branch that we may need to go a step further if we're going to be able to get the same share that everybody else has got. We're almost caught in a catch-22 between the maintenance of effort, the no supplanting in our 100% system, and we need to find a way out of that box. And that's the reason you got to, Mr. Chairman, I think that's the reason you got to hire some high-priced consultants. The system that the Supreme Court have given us has put us into a box on this, and we need to find a way out so we get the same reimbursement that everybody else in this country is getting. Mr. Chairman, there may be some complications, but I would sure urge us to pass this bill. I think the ultimate savings will be higher than your high end estimate. There's a real concentration for reasons having a number of fundamental reasons and reasons having to do with Medicaid eligibility. There's a real concentration of eligible kids in Medicaid eligible kids in special education. And I say everybody else has found it worth doing. So it's time we do.
Further discussion, Senator Rothfuss.
Thank you, Mr. Chairman. On the statewide concept, I think the key here is that all special education is already billed to the state. A subset of that is Medicaid eligible special education. So the system as it's presented is everything would be billed to the state for special education, and then the district would have to make a decision of a certain subset and then bill separately that to Medicaid at the state level for a double billing process. There's nothing that would preclude the idea that the first billing system would know which components are Medicaid eligible components because that's known. And I think the centralization could be as you bill to the state, there's no reason the State Department of Education can't forward over the billing instead of each individual district. I think logistically that's probably just fine. And then they would forward over to Department of Health would pay them, and it would roll back through. So I think there still is a logistical approach to administratively easing this on the districts where I don't know why they would necessarily have to care where their money came from. I don't even know that they would have to know where their money came from. The billing could almost be handled at the state level. That would be completely easy at the district level and would obviate any of the concerns about administration because we're just taking care of it. I think I think it's a great idea that the good senator from Sheridan suggested. So I don't think we should dismiss it quite yet, but again, on and for the bill. Thank you.
Further discussion, Senator Perkins.
I think that I appreciate the discussion and back when we were doing the efficiency commission, I mean, really, that's not very far off of what the ultimate recommendation was. This bill is not dealing with that specifically. This gets us started, but that's relevant to keep in mind because if this works, there'll be some action that happens in that direction. Ultimately, that was the recommendation of the efficiency commission. Ultimately, you would have some expertise housed down here at the state. Most of this information, like we've talked about, already comes in because they're already billing it. Just have to make sure that you've got all the information you need and that you have the ability to get it in the form that you need because it's a little bit different application process. But we're looking at all those things, but this is just getting a pilot program started. Most of that expertise will reside at the department to help us through that initially and to help the local districts with that. But those are things to keep in mind as we move forward. But like I say, I think that's certainly beyond what the scope of this bill is, but that's certainly where it's headed and things will need to take into consideration if this moves forward. Thank you.
Further discussion, or are you ready for the question? Question haven't been called. All those in favor of Senator Perkins' motion that when the committee of the whole rises to report, to do so with a favorable recommendation of Senate File 79, please say aye. Aye. All opposed, no. Motion carries. That bill passes committee of the whole. Senator Perkins.
Next bill for our consideration is Senate File 82, Local Impact Assistance Payments. So reading clerk, please read the bill.
Senate File 82, Local Impact Assistance Payments, an act relating to impact assistance payments sponsored by the Appropriations Committee, was referred to Committee Number 2, which returned to committee recommendation that it do pass amended. Aye, Senators Grew, Hinsky, Perkins, and Steinmetz. No, Senator Hicks. Senator Perkins, Chairman.
Senator, what's your pleasure? Senator Kinsky.
Yes, Mr. Chairman, thank you. I move that when the committee of the whole rises to report, it do so with a favorable recommendation of Senate File 82. Before I walk us through the bill, we do have a standing committee amendment I'd like to dispose of, and I'd ask the clerk to read that at this time.
Please read the amendment.
Senate File 82, Standing Committee Amendment Number 1, page 5, line 20, after.
Thank you, Mr. Chairman. I would move Standing Committee Amendment Number 1 to Senate File 82 and urge the body's favorable consideration. Folks, I would address, it's a simple amendment. I would address your attention to page 5, line 20, wherein we more accurately describe the sort of impacts that the Industrial Siting Council should be considering. And we say that they're looking at unmitigated impact means an expense incurred by a county, city, or town directly attributable to the construction. And it was the request of those localities that we insert the word indirectly because there are a number of impacts that are indirect. Your committee thought that was a good add to the bill. And so we did move that as a standing committee amendment, and I'll see if there are any questions on the standing committee amended at this time. Kinsky.
Are you sure?
I had to look inside my coat to get that. Thank you, Mr. Chairman. This bill, local impact assistance payments, by way of background, folks, you may recall when the coal mines first came to Campbell County, and Gillette was just a little spot in the road. I think there were about 2,500 people, and there was an extraordinary amount of impact. And ultimately, there'd be a lot of tax revenue accrued to the benefit of the community, but there was a delay in the collection of those. And I won't recite the entire studies that were done by Dr. Coors and the Gillette syndrome and so forth. It's familiar to all of us. But you zip ahead now, and we've got these impact assistance payments in place, but our communities are larger. Many of these projects don't have the length of gestation period that the coal mines did, so that they can get to collecting the revenues to offset the impacts more quickly. And because they're larger, they're able to absorb those impacts. Also, the magnitude of the dollars that is associated with these projects is such that the estimate is made by the Industrial Siting Council as to the impacts, and that money comes out of the state's general fund. In essence, it's diverted from money that would go to the general fund, and it's distributed to the localities. So there's a percentage of the estimated impact that's put into a pot, and then the towns and the governments start lining up, and they start outlining all the needs that they believe that they have. And when this sort of issue first came to your Appropriations Committee, I think we urged upon the staff of the Industrial Siting Council and their board to take a more critical view, as opposed to simply waving a lot of these lists of projects through, which is how it appeared. I'm not saying that they did that, but it certainly appeared that way. There wasn't much being denied. Since then, they've tightened up a little bit, and not 100% is approved. There's a much lesser percent, but still there's an extraordinary amount of money that's going out, and an extraordinary amount of money that is yet to go out, and that's diverted from the general fund to these localities. So this bill does a couple of things. One is, if it reduces the percentage of money that's diverted from the general fund to build this impact assistance program. And two, it makes more robust the definition that is to guide the deliberations of the Industrial Siting Council in terms of their awards, with the hope that they will be able to point to more direct impacts from this, and so that we can ameliorate the suspicion by some that it's simply a windfall that may not necessarily always be related to the impacts. So with that, let me walk you through the bill. On page 1, of course, we have the title, and then we begin with setting out the existing statute 39-15-111, the distribution of the impact money. And if you'll zip ahead to page 3, you will see the first amendment on line 10, where formerly the language said that in the award, the council is to state the reasons for determining an amount. That's now being amended to say, including specific findings of fact detailing the basis for the total dollar amount determination. And then in line 16, we have the percentage limitation, where 16 and 17, where the total dollar amount is moved from 2.76% of the total estimated material cost of the facility to 2%. The next change is on page 4, lines 2 through 5. We are being more specific about unmitigated impacts. In determining the distribution ratio, the Industrial Siting Council may consider the extent and location of the unmitigated impacts, the populations of the affected counties. In other words, is a very small population that can't absorb the impact, or a larger population that may already have the necessary infrastructure, the populations of affected counties, cities, and towns, and any other equitable factor. Then if you'd go ahead to page 5, we have what we hope is a more robust definition of unmitigated impact, beginning with subparagraph large A on line 19, incurred by a city, county, or town directly or indirectly attributable to the construction. And then on page 6 at the top, that must not be otherwise mitigated by any other entity, e.g. the project. And then beginning on line 4 on page 6, we're outlining some specific things that do merit consideration: medical services, fire, law enforcement services, roads, public utilities. Continuing expenses shall be supported by an analysis prepared by the county, city, or town of the current excess capacity in each of these areas. And expenses in the areas may include the employment of additional employees or officers only if the city, county, or town has determined overtime compensation or contract labor would not be appropriate. Then on line 13, we begin with a series of exclusions. Line 15, excluding expenses relating to improvements and existing structures beyond that necessary to return it to the condition that it existed in before the construction of the industrial facility. Line 20, excluded are expenses for which a city, county, or town previously received an impact assistance payment unless they can demonstrate that the expenses are new or ongoing. So it's hoped that that will help guide the Industrial Siting Council to take a sharper pencil to some of these applications. Going ahead to page 8 on line 16, we see again the repetition of the requirement that they include specific findings of fact detailing the basis for the total dollar amount determination. And at the bottom on line 23, again, the reduction of the total amount. And on lines 8 through 12, a repetition of the language in determining the distribution ratio that they're to consider unmitigated impacts, populations, and other equitable factors. And I believe, no, and then on page 11, it simply is the definition section. Unmitigated impact means that what we just defined in the previous pages as we went through them. So with that, that is a quick run through on the bill. I did want to share with you some of the information that was presented to the committee that impacted our consideration, if you will. Since 2018 to 2020, there has been $78 million in impact assistance awarded to communities with regard to Trona, transmission line, wind developments, and so forth. And then there are a number of large projects in the making, some of which the Industrial Siting Council couldn't estimate what those possible future project payments might be. But of those that are currently under construction or those that are on the drawing board that have not yet begun construction, we are slated to pay out up to another $36 million. And then the Industrial Siting Division said that they've met with 4 other developers that may have a high impact. They have not yet filed, but those projects have another $90 million in potential impact assistance payments. So it's a significant amount of money that is being diverted from the general fund to the local communities. This bill, we think, strikes a good balance between still making those payments available, making them available where it can be demonstrated that it is related to the impact of the development, and at the same time being respectful of the state's desire to hang on to a little bit of that money if it's not, strictly speaking, necessary to mitigate the impact. So with that, I will stand for any questions. Thank you, Mr. Chairman.
Thank you, Mr. Chairman. I appreciate the work of Appropriations Committee. This is absolutely an issue that has to be addressed. Having gone through this process, and Commerce County actually sat in one of these meetings, or I could say that the council does need some more direction. We're kind of, absent any concrete definition, especially of unmitigated impact. What I observed, at least in one instance, was there's no really attempt to make a judgment call as to the validity of the claims that in this case included many different municipalities in the central part of the state. And I think due to the attention is getting from the JAC, that the end result was just a flat across the board reduction in the request, regardless of the various methods of justifying the requests coming from these municipal and county governments. So I appreciate especially the definitions, the requiring of a specific findings. I think all those help out potentially more than reducing the overall ceiling amount. But I just had some questions about it towards the end of the bill on page 9 and determining the distribution ratio. It's good that we have the extent and location of unmitigated impacts, but I just need a little bit more explanation as far as why the population of affected counties or any other equitable factor, how does that play a role, and are we leaving that too wide open? If we add in kind of a catch-all other equitable factor, what does that mean? I think we all have, everyone's gonna have a different idea of what equitable is if we're not defining it. And I just would hate to see that part of the bill undermine the rest of it. That provides very clear and much needed guidance to the Industrial Siding Council as what is actually an unmitigated impact, what it isn't. So a very overall minor concern with the bill. It probably just needs an explanation, but overall commend to the Appropriations Committee for this good work.
Thank you, Senator Bonner. Senator Hicks.
Mr. Chairman, on and against the bill. And let me explain why. And getting back to my colleague and my roommate and the description he gave in the industrial siding, one of the issues that the reason that a lot of those payments were paid out as high as they were before, based on all the testimony we read, it gets right to what this bill addresses as the unmitigated impact. And so the Industrial Siding Council did not have the specific, it was very vague and nebulous as to what was eligible. So consequently, they took a liberal approach and awarded money to those cities, towns, and counties. They have come back and said, even the Industrial Siding Council, we can do a better job because they're not obligated. They are not obligated to award all the monies that are available. With the new language in here, it addresses that issue because now we've provided guidance as to what an unmitigatable impact is. So it tightens up that definition of what those cities, towns, and counties can be awarded for. And if the bill just did that, Mr. Chairman, I would stand in favor of the bill. But it doesn't do that. And so what it does do, and because my colleague and my roommate here likes to use percentages when it comes to tax increases to show the relative impact of the taxpayers. Let me tell you what it does on the reduction side. It's a 38% reduction in funds available for your cities, towns, and counties. 38% reduction. Now, that's not to say that with the new language that they would ever be eligible for that $90 million that's out there. But what it does say is that money is on the table if the Industrial Siding Council made a determination with the new definition that there was impacts. It takes that money off the table for those cities, towns, and counties. Mr. Chairman, one other thing that I would like to dispel about how this is no longer needed, because these industrial developments have happened in areas where we've been able to absorb them because of the size. Well, let's talk about where some of these industrial developments have been. And quite frankly, I don't think Medicine Bow qualifies as an area that's had the ability to absorb all the impacts, nor do I think Rock River has, nor do I think Hannah has, nor do I think Elk Mountain has. So these industrial complexes are going into these little bitty communities that are creating a tremendous impact on emergency services. We barely have the ability to maintain ambulances within our areas. And now you're going to go in and say, well, you know, that's just not an eligible expense because you're too big of a community and you can absorb those impacts. When you increase the traffic on those county roads and the wear and tear of those bridges and the increase in police services, fire, infrastructure, we got man camps bigger than whole cities associated with some of these projects. Let the Industrial Siding Council do the job for what they were established to do. This language provides them all the opportunity to go in, analyze all those impacts to your cities and your towns with a new definition, and comes back and tightens up that eligibility. But to take 38% of the available funding away from these communities that are having these impacts, I think is a disservice. Thank you, Mr. Chairman.
Thank you, Mr. Chairman. I'd just like a clarification from the sponsor. It does seem to me that that's an easily amendable point and that these are two separate policies that are available here. One is the percentage, the other has a lot to do with the procedure. And so I would just ask if that's accurate, that if we do pass this along through committee of the whole, that could be a potential second reading amendment where we just independently vote on the value of the percentage that would go forward. So that's my reading, and I would just ask the sponsor if that's an accurate take.
Thanks,
Chairman,
Senator.
we can't hear
Senator
you.
Cole.
Thank you. Yeah, the Industrial Siting Council came into existence while I started to be a commissioner. I've seen the whole process from the beginning to where it currently is now. And it's certainly not perfect. And it wasn't perfect before, you know, it's a balancing act between who decides needs. And when we got this particular situation where, of course, the Industrial Siting Council is supposed to make these decisions about what are the true needs. And I think that's probably the best place for it. But I think cutting the 38% out of it probably isn't a good idea, because if the Industrial Siting Council is doing their job, they will make the determination of real impacts. And while it's true some communities are going to face larger ones than others, that's a fact. But however, the Industrial Siting Council's charge is to look at that. So I think we have to give them flexibility, and cutting the budget by 38% of the potential projects probably wouldn't be in the best interest for those smaller communities or communities that need to be addressed because of their larger impacts. Thank you.
Thanks, Senator Cole. Senator Landon.
Mr. Chairman, thank you. I appreciate the previous two speakers touching on something that has been on my mind since I read this bill. I don't very often get the opportunity to talk about the small community I have the privilege of representing. But it's a little community where we have our veteran cemetery and just one little entrance into that community and one exit, same road that does both. And it tends to get a lot of the impact that my friend from downriver was talking about. You know, all of this development in the central part of the state, a lot of our workers, you know, they don't necessarily live in some of the neighborhoods around where I'm privileged enough to live. They live in the smaller community. And it doesn't take very much, Mr. Chairman, before any sort of impact like we're talking about in this bill becomes very significant to them in terms of fire and police and the little bit of road work that they can do, or the preparation for some of the impact that they do get. So, you know, I'm willing to pass this on and keep a close eye on it, but I am concerned about the level of cuts to this assistant funding. Thank you.
Thanks, Senator Landon. Further discussion. Senator Kinski.
Thank you, Mr. Chairman. First, with respect to the question of my friend for the ivory tower about isn't this bill easily amendable, I want to be careful in my answer because I'm chairing the committee of the whole tomorrow. And I've seen you stand up and call for divisions on amendments that when I've heard that, I've thought, thank goodness I'm not chairing the committee of the whole. I'm not sure I could follow that one. So I would say yes, if it's a simple amendment. Just, I want to defend myself. So it is easily amendable, and I think they are two discussions, the amount of the reduction in the size of the fund and the criteria that are outlined. And I heard my friend from Bags, as well as my friend from Rock Springs say that the criteria is perhaps the most important part of the bill, and they endorse that. So I think that alone calls for an aye vote on first reading. My friend from, what did they say, the greater metropolitan area of, what was it? Orange Junction. Yeah, the greater metropolitan Orange Junction area. you had asked about why is population called out? Well, it's called out specifically for the reasons that the senator from Baggs mentioned. You know, if it's a very large community and in there, they've got sophistication, they say, you know, here's our wish list that we didn't get in our last budget cycle out of the city council. We've just decided these are impact related. You can say, you know, you're a town of 20,000 or whatever. It's just, it's a harder case to make. And so we are specifically calling out population for the Medicine Bows, the Rock Rivers, the Hannahs, the Elk Mountains, that when they are smaller than the size of the man camps that are impacting them, that argues to the ISC that the award should be disproportionately greater to those communities than to the larger, more developed communities. So I think what the senator from Baggs and the senator from Warren Junction were talking about is exactly the same question. My friend from Warren Junction also asked about the language, any other equitable factors. I will tell you, I had some misgivings about that as well. It seems to be an exception you could drive a truck through, but we heard, I think, from the localities that they felt that was a good thing to be in there as just kind of a just in case. And as I recall, I don't think there was resistance from the Industrial Siting Council staff about that. In fact, they may have agreed to that, but I guess I would say that also is easily amendable on second reading as long as it's not really complicated and subject to division. Thank you, Mr. Chairman.
Thanks, Senator Kinski. Senator Bonner.
Well, thank you, Mr. Chairman. Appreciate that. And that's a good clarification. Might benefit from a second reading amendment. At least from what I remember from a year and a half ago, there's a tendency, at least maybe my perspective is a little biased, to give greater weight to more populated areas. The idea being that the workers are going to flock towards those more populated areas because all the amenities they had, and cause, you know, apparently driving their pickup truck back home every day is as much of an impact as driving a semi truck across the county road right in the middle of the actual project area. So I think if that's the intent, and I agree with that intent, to make sure that we take into account these municipalities' abilities to achieve these efficiencies of scale, perhaps hopefully that's a simple second reading amendment that my good friend Sheridan wouldn't object to. So just make sure that there's clarity throughout the bill, make sure we're achieving the objective.
Thanks, Senator Bonner. Senator Nethercott.
Thank you, Mr. Chairman. I have to agree with the good senator from Baggs. You know, there's an always a strong desire to provide more definitions, but in reality, what you're doing is you're tying the hands of a council that is designed to hear evidence and testimony from both sides of a party, and then using their subject matter expertise to determine whether or not a population size based on the project and other equitable factors, which I find an appropriate standard, both for the Public Service Commission and the Industrial Siting Council, to be considered. But when you put in these exceptions and you start narrowing it down, you're going to create an absurd result for the council to weigh all of those facts and how they interplay with each other. And I think that that is a dangerous precedent that will have unintended consequences for scenarios that are unseen moving forward in the future. I also think that it's inconsistent statutory language when we look at the design associated with the direction to the Siting Council to review other equitable factors, and then moving down, specifically directing them to exclude certain equitable factors. And so I just don't think it's the result you want after what is a contested case hearing, where you have multiple parties, at least two, presenting evidence before a council to weigh and consider how they might interplay together, to then ask them to weigh all of those factors, conduct a hearing, findings of fact, conclusions of law, recommendations, considerations, and then go back and exclude these specific things to understand how they then interplay based on these statutory exceptions. I understand the desire to want it, but I think there are unintended consequences with tying those hands that are really unforeseen. And so let's leave it to those subject matter experts who are designed to evaluate that evidence at the time and make appropriate decisions.
Thank you, Senator Nethercott. Senator Hickінський.
Yes, with regard to my colleague from Cheyenne's statement that she agrees with the senator from Baggs, I'm going to put that as a red letter date on my calendar, March 1, 2021, because I don't know if that'll be repeated again this session.
5/19.
To my 5:19 PM. To my friend from Orange Junction, I think that I think your caution is probably in order to clarify that when we say population, what we're calling out is disproportionate impact on those smaller communities. And so I'd welcome the opportunity to see whatever you might want to do on amendment on that. That's certainly the way I read it. But if we want to make sure that's the way the ISC reads it, we'd better get some clarifying language in there. Thank you, Mr. Chairman.
Thanks, Senator Kinski. Are you ready for the question? All those in favor of Senator Kinski's motion when the committee of the whole rise and report that do so with a favorable recommendation on Senate File 82, say aye.
Aye.
All those opposed, say no.
No.
The ayes have it. The bill is passed. Committee of the whole. Next bill for our consideration is Mr. Majority Floor Leader.
Mr. Chairman, I move that the committee of the whole rise and report. One promise kept, 520.
Okay. You've heard the motion. All those in favor say aye.
Aye.
All those opposed say no. Motion carries.
Good job.
Okay, the reading clerk will read the committee of the whole report.
Mr. President, your committee of the whole, having had under considerations bills on general file, begs leave to report as follows. Senate File 52, do pass. Senate File 44, do pass. Senate File 19, do pass amended. Senate File 15, do pass. Senate File 9, do pass amended. Senate File 5, do pass amended. Senate File 13, do pass. Senate File 88, do pass amended. Senate File 33, do pass amended. Senate File 79, do pass amended. Senate File 82, do pass amended. Senator Perkins, Chairman.
Senator Perkins.
Wait a minute. Thank you, Mr. President. I move adoption of the committee whole report.
You've heard the motion. All in favor, say aye.
Aye.
Those opposed? Committee, the motion is passed. The report has been adopted.
Mr. President,
President
may I have privilege of the floor?
Please do.
Thank you, Mr. President. I just wanted to, it was the first day of committee of the whole here back in person. Just wanted to say that I appreciated the debate today. The only thing it was a good day. I think it was a good start as we knock off the rust and get back into the rhythm of having this in-person session. I just would remind members, Mr. President, that during the debate, so when we're doing the debate, that to avoid the use of proper names, particularly names of individuals, that happened a few times. It always happens when at the beginning, and just wanted to bring that to your attention. To just remind you that we do that. And Mr. President, that speaker didn't work for me anytime today either. So the fact that you can't hear me makes me feel better. Thank you.
Thank you, Chairman Perkins. All right, well, Mr. Majority Floor Leader, that clears the desk.
Mr. President, I move the Senate adjourns until 10 o'clock tomorrow, March 2nd.
Announcements. Chairman Ellis.
Wow, noon.
Thank you, Mr. President. Committee 6, Travel, Recreation, Wildlife will meet tomorrow morning at 8 a.m. in the Capitol Extension Room W2, as well as on Zoom, to consider nominees for the Wyoming Gaming Commission, as well as Senate File 103. Thank you, Mr. President.
Let's go over here to Senator Boner, Chairman Boner. And we'll get this all figured out. Okay.
Thank you, Mr. President. Your committee number 5, Agriculture, State and Public Lands and Water Resources, will meet upon adjournment tomorrow, March 2nd, in Capitol Extension Room W2, as well as online, to consider Senate File 114, State Land Leases, and Senate File 122, Wyoming Agriculture Authority, if introduced and referred.
Thank you, Chairman Boner. Chairman Landon.
Thank you. Mr. President, your Senate Transportation Committee, which is always going somewhere, will be headed out here in about 15 minutes to meet down in the viaduct, just past the toll booth in room 2.
We had some
Mr.
suggestions.
President, we're going to take up Senate File 7, which we began deliberations on February 25th. We'll finish up autonomous vehicles. Senate File 106, Transportation Statutory Amendments 1, and Senate File 107, Statutory Amendments 2. Again, room 2 down below your Senate Transportation Committee. Thank you.
Thank you, Chairman Landon. I think we had some discussion that toll booth would fund the Senate lunch fund. All right. Majority Floor Leader Driscoll.
Mr. President, your lucky committee number 7, Corporations, will meet tomorrow, March 2 at 8 a.m. in the State Capitol Room W110 and online to take up Senate File 46, which is partially done already, air ambulance memberships. Senate File 86, Attorney General elected official. If time permits, Senate File 102, unclaimed cooperative utility deposits. Senate File 36, for-profit benefit corporations. And Senate File 78, real estate appraisers.
Further announcements? Chairman Perkins.
Thank you, Mr. President. Your committee number 2, Appropriations, meet tomorrow at approximately 12:15 or 15 minutes after the noon recess to take up Senate File 93, which is WICHE repayment, program veterinary medicine students, and also any re-referrals, which particularly we've had, I think, the re-referral of Senate File 3 this morning. Thank you, Mr. President. Oh, Mr. President, that meeting, we'll be meeting in E301.
Thank you. Could I, Mr. Majority Floor Leader, would you do the Rules Committee announcement?
Mr. President, I don't have a committee assignment. I do have an announcement that the Senate will briefly caucus immediately on adjournment to take up governor's reappointments to the refilled people. So it'll be a short one right here.
Clarification, that will be just right after we meet here tonight, right?
Right after what?
The caucus?
Yeah, as soon as we adjourn.
Okay, thank you. And also I have an announcement, Rules Committee will meet at 8 a.m. in W4 tomorrow morning, 8 a.m. Okay, I have a further announcement here. It's a reminder for tomorrow, Governor Gordon is scheduled to give his State of the State address to the full legislature, followed by the State of the Judiciary by Chief Justice Michael Davis, Tuesday tomorrow, 10 o'clock in the morning. There will not be a morning Zoom session for the House and the Senate roll call. Roll call, the prayer and pledge will take place at the beginning of tomorrow's afternoon floor session. So repeat that again. There will not be a Zoom morning session for the House and the Senate. Roll call, the prayer and the pledge will take place at the beginning of tomorrow's afternoon floor session. Governor and Chief Justice Michael Davis speaking to us at 10 o'clock. For those in the chamber for this, you will be able to view the State of the State and State of the Judiciary from your desk on the large monitors in the chamber. Wyoming PBS will stream the event live beginning at 10 o'clock in the morning. For those joining remotely, Senator Anderson, do not log into the Zoom meeting until the afternoon floor session is scheduled to begin. You can watch both addresses on the Wyoming PBS YouTube channel. And public viewing in the Capitol, the public will be able to hear that address in the chambers. Public meeting room W113 will also have a live stream of that event. All that going on tomorrow. Vice President.
Myself, and I think members of the body. So we will convene at 2 o'clock tomorrow during our normal time. Is that correct?
That is correct.
All right, 2 o'clock.
Okay. All right. Is that it for announcements?
We'll just go back into committee.
All right, you've heard the motion. All those in favor, say aye. All those opposed, say nay. So tomorrow morning, resume at 10 o'clock in the morning for the addresses, 2 o'clock in the afternoon, Tuesday, March 2nd. Senate stand adjourned.